Good morning. Welcome to today's hearing of the Yoorrook Justice Commission. This is a continuation of our inquiry into land injustice, hearing block 6. I would like to invite Commissioner Hunter to give the welcome to country. Commissioner Hunter.
Thanks, Chair. I'd like to acknowledge that we are on the lands of the Wurundjeri, of my father's lands. I'd like to acknowledge ancestors and elders and all those that came before us to give us voice in this room today and throughout the time of Yoorrook. And when I say Wominjeka, it means to come with purpose, and that's what I hope we all bring to the hearings every single time we come into this room. So Wominjeka and welcome.
Thank you, Commissioner Hunter. I'd just like to make some introductory comments before we get going, and thank you, Commissioner Hunter, for that welcome. And I'd just like to introduce fellow commissioners, Commissioner Hunter, who is the lead on the Commission's health inquiry, Commissioner Lovett, who is leading the Commission's land and justice, housing and economic life inquiry, Commissioner Walter, who is the lead on the Commission's education and economic life inquiry, and Commissioner North, who has recently joined us first time on these lot of hearings, so welcome. This Royal Commission has been tasked with uncovering the truth of the historic ongoing systemic injustices experienced by First Peoples in Victoria. I have said it is the most important work that I will ever do. It is the hardest task also for so many of us. These land justice hearings are about who we are, our identity, our relationships to place and country, and the brutal impact of colonisation and loss. In 1968, Bill Stanner referenced the Great Australian Silence, leading to a failure to acknowledge the atrocities of the past, to forgetting that they happened at all. As a result, a different history arose in the Australian memory and formed negative stereotypes, marginalising First Peoples and enabling continued systemic discrimination. 60 years later, just last year, in Victoria, we had a failed referendum, but we also had Yoorrook, formed on the advice of the elected First Peoples Assembly. In addition to this state government has been committed to treaty making for almost a decade. The testimony provided to Yoorrook now includes our voices, your voices, the voices of all Victorians who have come before Victoria, before Yoorrook. For example, as having Susanna Henty appear from another side. This is historic. It will contribute to a more inclusive narrative about the founding of the state of Victoria. I expect the evidence gathered by Yoorrook to be used to educate the following generations about the shared history of this state. I anticipate that much of Yoorrook's work will also form part of an expanded and extensive education curricula for teacher education professionals and within TAFE. I would now like to ask Commissioner Lovett to say a few words, introductory words.
Thank you, Chair. And also thank you, Commissioner Hunter, for that welcome to country and the importance of the word Wominjeka as well. Latta latama latun latinyung Travis Lava Kiramar Gunijmar meeting Linian Kukon Kenen Konletedek Bujabim Humbin meeting Warandri Ma meeting Kulin meeting Nian Karabanjul Wangwa Ma Wuran Buka Bidarong Purity meeting Narakitong Ma Mien and Mo. Yoorrook's land injustice hearings commenced a few weeks ago in Portland, Victoria, which has inaccurately been called the birthplace of Victoria. The evidence taken by Yoorrook in the first week of hearings helped to clarify that the squatters that came to Portland to set up an illegal whaling colony. This then started a lawless land grab across Victoria that changed the lives of First Peoples forever. We heard from historians Richard Broome and Henry Reynolds about how the occupation of Victoria by squatters was the swiftest and most rapid expansion of any colony in European history. Professor Ellinghaus, Professor Andrews and Professor Pascoe provided chilling evidence on the genocide that occurred through Tasmania and Victoria. Evidence was given to Yoorrook about the clear correlation between the rapid expansion of squatters in the 1840s and the peak of massacres of First Peoples. Yoorrook was told that even the Parliamentary Select Committee in the House of Commons in Britain in 1837 considered the actions of squatters and the violence against First Peoples in the colonies to be criminal against the standards of the day. We heard that in the paternalistic spirit of protecting First Peoples against ongoing massacres, our communities were put onto missions and reserves. From this point on, First Peoples' lives were completely controlled by the state. As Uncle Jim observed, missions were meant to protect First Peoples, but instead they punished our people for practicing culture and speaking language. Auntie Jill told Yoorrook that if you practice your culture on the mission, you lost your rations. Auntie Vicky described the resulting linguicide of Aboriginal language that resulted from the forced removal to missions. Professor Marsha Langston told the Commission the loss of Aboriginal languages in Victoria is among the greatest in Australia, and that in turn, Australia has one of the largest extinction rates in the world. Language extinction rates, to be clear, in the world. Commissioners were deeply moved by letters read by Auntie Jill that were written by Aboriginal women in the protection era who desperately wanted to be reunited with their children or provide for their families. We received evidence. The letter from Eliza Saunders in 1915 to the Board of Protection seeking permissions to leave the mission and occupy a home that she was able to buy from the savings she had accumulated. She was denied her request and her rations were ultimately taken away. She returned to South Australia and was never able to buy her own home, despite having the means to do so. In Professor Reynolds' words, the original sin of Australian colonisation as the assumption that First Peoples didn't have property rights. The original sin was the beginning of the unbroken line of injustice for First Peoples that continues today. Following the line of injustice that helps us connect the massacres in the 1800s and the detention of First Peoples on missions and reserves with the high rate of incarceration and deaths in custody of our First Peoples in the present day. It helps us to understand why languages have disappeared and the resulting impact that this has had on our culture. This week we will hear about the next important phases in Victoria's history as we begin to shift the focus of evidence from historical into contemporary issues. We will hear evidence about the resistance and transformation that First Peoples have managed to achieve against the odds. I will now hand back to the Chair to commence the formal evidence. Thank you.
Thank you, Commissioner Lovett. May I have appearances, please, Council, and ask you also to outline the evidence that will come before the Commission today.
Chair, Commissioners, I appear as co-senior counsel assisting in the hearing block this week and in the weeks following, together with co-senior counsel assisting Fiona McLeod SC, who was in the hearing room today.
Good morning, Chair, Commissioners. My name is Gemma Caffarella, and I appear on behalf of the State of Victoria today. On behalf of the State of Victoria, I would like to thank you, Commissioner Hunter, for your welcome to country, and I would also like to acknowledge the comments made by you, Chair, and Commissioner Lovett on the importance and the difficulty of this work. The State acknowledges that today's hearing is being held on the lands of the Wurundjeri people, and I acknowledge them as traditional owners of this land. Sovereignty was never ceded over this land. The State pays respect to Wurundjeri elders, past and present, and I acknowledge all First Peoples elders and First Nations people who are here today and also watching online. Thank you.
Chair, Commissioners, Council assisting acknowledges that we are here today on the lands of the Wurundjeri and acknowledges all of the First Peoples of this place we now call the State of Victoria. We thank Commissioner Hunter for her welcome, and we note the opening comments of the Chair and Commissioner Lovett. This morning we will hear evidence from a panel on the topic of resilience and transformation. That panel is comprised of Karen Jackson, Dr. Julia Hurst, Uncle Graham Atkinson, and Marjorie Thorpe. After lunch, Commissioners, we will hear from Craig Sandy, Surveyor-General of Victoria, and the evidence today will conclude with a panel on First Nations water rights comprised of Dr. Erin O'Donnell, Dr. Katie O'Brien, Carmen Jobling, and Will Mooney, the last two are from the Murray Lower Darling Rivers Indigenous Nations. They are the witnesses for today. In addition, before we move to the first panel, I wish to make a short opening for this part of hearing block number 6. Chair, Commissioners, as has just been described, today marks the continuation of the Land Injustice hearing block. The Commission has heard absolutely remarkable evidence already regarding the catastrophic impact on First Peoples of what was then called the Port Phillip district when the British arrived at this corner of the continent. As Commissioner Lovett has just explained, Emeritus Professor Richard Broome described the speed at which the land grab in these parts occurred as the fastest ever European expansion in other territories. Commissioners, by the end of this hearing block, we suggest that the Commission will be satisfied that the British government and the New South Wales government in the form of the Governor knew that the arrival of British migrants in the Port Phillip settlement would be disastrous for First Peoples. They knew because they had seen it all happen before in Canada, in Port Jackson, and particularly in Van Diemen's Land. But we say, Commissioners, the loss of life was not inevitable, but it was a known consequence of the land theft that was to take place. The evidence to be tendered will also show that as at 1835, when the Port Phillip settlement was created, the British government and the New South Wales governor knew that the First Peoples of what was to later become Victoria had existing rights, and that those existing rights ought to have been protected. In some places, Commissioners, in the material that has come before this Commission, the 1835 proclamation by Governor Richard Burke to the effect that people could only acquire interest in land through the Governor of New South Wales and that squatters would be prosecuted for trespass, in some places that proclamation is taken to be an assertion of terra nullius over the whole of the colony. However, the evidence will support an understanding of that proclamation that it was to be directed to the squatters as to their conduct and their lawfulness, and not a denial of the existence of any rights in the possession of First Peoples. We know that Governor Burke was appointed by King William IV on the 3rd of December 1831. And we know about King William that during his reign, King William IV, that during his reign, slavery was abolished in most of the British territories. And we know that in 1836, King William IV also issued letters patent for the establishment of the state of South Australia, which specifically protected First Peoples' rights. And interestingly, Commissioners, the Commission and the letter of instruction to Governor Burke from King William IV is missing. Another document, another very important foundational document for the colony that can't be found, just as we are yet to see the final instructions to Governor Arthur Phillip, and are left to rely upon the draft instructions as an assertion of the acquisition of sovereignty. It is also relevant to note that in the United States of America, at the same time, a series of cases decided upon in the United States Supreme Court by Justice Marshall, dubbed those cases are dubbed the Marshall Trilogy, occurred between 1823 and 1832. So remember, the Burke Proclamation was 1835. Justice Marshall determined that land could not be purchased by private citizens from the Native Americans, and that was in 1825. It's very familiar words. It's the same as the Burke Proclamation. But then he went on in other judgments to say that the Cherokee Nation existed, and it was dependent upon the United States. And finally, in the third decision, setting out the relationship between Native American nations and the federal and state governments. So the British government was aware of this. It was happening in the United States of America, and it was happening at the time that the instructions for Governor Burke were issued by King William IV. In the coming weeks, the Commission will hear evidence from community members, community organisations and government ministers and officers in respect of land, environment, water and statutory recognition regimes such as the Aboriginal Heritage Act, the Native Title Act and the Traditional Owner Settlement Act. While necessarily considering the present day arrangements and what is possible in treaty, we say as Council assisting that the evidence needs to be understood in the context of the true history of this place. At the end of this hearing block, Commissioners will be left in little doubt as to whether the application of the doctrine of terra nullius came much later than the 1835 Burke Proclamation and amounted to a rationalisation after the fact of invasion and dispossession, and that there has been at play in the colonies in New South Wales and Victoria a strategy of delay and obfuscation, of being seen to act but not acting. The decision in Mabo versus the State of Queensland number 2 in 1992 rejected the doctrine of terra nullius, and at that point, it would seem that the reliance upon that legal fiction to support the lawful acquisition of Victoria at least becomes arguable and possibly unsustainable. Yet the various governments in Australia have continued on with the alienation of land, water and resources without seeking to engage properly with the very fundamental issue of their own legitimacy, nor seek the consent of First Peoples. With those historical underpinnings in mind, we will call this week evidence from First Peoples as community members and academics, other water academics, and First Peoples with expertise in international law. We will hear from government officers, ministers of the government, finishing with evidence from the Honourable Jacinta Allen, the Premier of Victoria at the end of the hearing block. In part, Commissioners, the focus of these hearings will be upon the terms of reference that empower this Commission to inquire into historical injustices, but also very much upon the pressing questions of continuing injustice and what recommendations may be made to ensure that the report of this Commission and its recommendations are given full weight and acted upon with purpose and in a timely manner. In this regard, it is appropriate to remember the words of that great Aboriginal leader, Charles Perkins, as was recorded in his 1990 biography by author Peter Reid, when speaking at the Rotary Club of Melbourne on the 26th of January 1984. He said, "I am a descendant of a once proud tribe from Central Australia, the Arunta people. Today we number very few and own nothing. We cringe like dogs at the prospect of the white backlash. We pray eternally that the white authority structure will not turn on us and impede what little progress we have made. We ask for land rights with tongue in cheek, knowing full well in our hearts that the land belonged to us in the first instance. We stagger and stumble into each other in confusion when our identity is contested and thus allow ourselves to be moulded by others. Our land, our pride, and our future has been taken away from us and our people buried in unmarked graves. We wander through the Australian society as beggars. We live off the crumbs of the white Australian table and are told to be grateful." This is what Australia Day means to Aboriginal Australians. We celebrate with you, but there is much sadness in our joy. It is like dancing on your mother's grave. We cannot live in the past, but the past lives with us. The words of Charles Perkins are words of strength and defiance. They are words of resilience. Commissioners, it is clear from the First Nations witnesses that have appeared in all the hearings before this Commission that those traits have not diminished or withered. This morning we will hear evidence from a panel on resilience and transformation. As I've said, comprised of Karen Jackson, Dr. Julia Hurst, Uncle Graham Atkinson and Marjorie Thorpe. After lunch we will hear from Craig Sandy, the Surveyor-General of Victoria, and we will conclude the day with the First Nations Water Rights panel comprised of Dr. Erin O'Donnell, Dr. Katie O'Brien and Carmel Jobling and Will Mooney as panellists from the Murray Lower Darling Rivers Indigenous Nation. Commissioners, I propose now to request a short adjournment to ensure that the first panel of witnesses may be set up. Thank you.
How long are we talking?
5 minutes, please, Commissioner.
Thank you, Council, when you're ready.
Thank you, Chair. If the Commission pleases, I now call the first panel for today, comprised of Karen Jackson, Dr. Julia Hurst, Marjorie Thorpe, and Uncle Graham Atkinson. I might swear each and then give them an opportunity to introduce themselves, Commissioners. And I'll start from this end and work my way along. Firstly, Karen, could you tell the Commissioners your name, please?
Karen Jackson.
And in the evidence you're about to give to the Commission, will you tell the truth to the best of your knowledge?
Yes.
Thank you. Dr. Hurst, could you tell the Commission your name, please?
Julia Hurst.
And in the evidence you're about to give to the Commission, will that evidence be the truth to the best of your knowledge? Thank you. Marjorie Thorpe, could you tell the Commission your full name, please?
Marjorie Ann Thorpe.
And in the evidence you're about to give to the Commission, will that evidence be the truth to the best of your knowledge?
Yes, it will.
And Uncle Graham Atkinson, could you tell your name to the Commissioners, please?
Yeah, Graham John Atkinson.
And the evidence you're about to give to the Commission will be the truth to the best of your knowledge?
Yes.
I might just start at this end with Karen Jackson. How do you prefer to be addressed for the purpose of this hearing?
Karen's just fine, thank you.
Thank you. Could you just take a moment to explain to the Commissioners some of your background and introduce yourself? Thank you.
Hello. I do know most of you, but Karen Jackson, also known as KJ sometimes, Yoorrook Justice Executive Director at Moondunny Ballock Indigenous Academic Unit at Victoria University. And a lot of my work is around transformation, I guess, in the suburbs of the west of Melbourne with the Aboriginal community that have been stolen and displaced. Thanks.
Dr. Hurst, how do you prefer to be addressed for the purpose of this hearing? You don't want to be called Dr. Hurst?
No, there's lots of knowledge here. And I'm fine with Julia.
Would you take a moment to introduce yourself to the Commissioners, please?
Julia, I am an Aboriginal woman whose family has been intimately connected to the stolen generations. My mum was born in secret and had a silent adoption here in Melbourne. And our history has been about reconnecting with our families in Sydney. Our family crosses Darug and Dharawal country. And most of my work has been around storytelling, connected to stolen generations, belonging, and finding connections to country. I work at the University of Melbourne as a historian. I began that role in 2020, and I also work as a Deputy Director of the Australian Centre. I'm an oral historian, so I work a lot with the National Library of Australia, and most of my work is about bringing stories across generations to light.
Thank you very much. Marjorie Thorpe, how would you like to be addressed for the purpose of this hearing?
Well, Marge or Margie is fine.
And could you take a moment to introduce yourself to the Commissioners?
Well, my name's Marjorie Thorpe. I'm a senior Djapurrung woman and a elder of the Gunai Kurnai peoples of Gippsland.
Thank you. And Uncle Graham, how do you prefer to be referred to?
Yeah, look, I don't have an issue. I'm often referred to as Uncle Graham. If people want to refer to me as Graham, that's fine as well.
And could you take a moment to introduce yourself for the Commissioners?
Yeah, just briefly. I inherited my Yoorrook Justice identity and culture from a very strong family background, upbringing, from my elders and also my ancestors. Formerly was a former Yoorrook Governance Committee member back in 1998 to 2005. I was a former owner, director of Atkinson Consulting Group, but I've retired from full-time work. Former chair of Native Title Services Victoria, 2003, 2014. Former co-chair of the Victorian Land Justice Group, 2005, 2010. Currently a member of the Djadjabberung Lands Aboriginal Corporation and currently chair of the Dalkunya, which means caring for country, Dalkunya Land Management Board, which was set up under the Recognition and Settlement Agreement that the Djadjabberung successfully negotiated directly with the state of Victoria back in September 2013. I'm very involved in my community. My role in whatever position I've held has had one goal in mind, and that is, can I make a difference in what role I perform? And so that is where I, the background that I bring to today's hearing.
Thank you very much. I propose to start with some questions about the battle for Blake Tyres, and I might direct the first question to Marge. You're a member of the Lake Tyres Aboriginal Trust?
Yes, I'm a shareholder of the Lake Tyres Aboriginal Trust.
Could you tell the Commission from your own experience what the history is behind the trust?
Well, in 1970, there was a legislation was passed after protest from elders of Lake Tyres who protested at the they were going to close Lake Tyres Reserve down. So those elders came to Melbourne and protested along with Sir Douglas Nicholls and members of the Advancement League and other people protested outside Parliament House to stop that from happening. And as a result of that was the 1970 Land Act, which was established to manage Lake Tyres. Prior to that, there was a significant movement of people from Lake Tyres into surrounding towns, and they were dispersed across Victoria at that point in time. So a lot of people were moved. Prior to that act, it was reserved, so people weren't allowed off that reserve without permission. And if they did try to leave the reserve, they were rounded up and taken back by the police. So, so as a result of that Land Act, that was the management of Lake Tyres was transferred to those shareholders who were living on that 4,000 acres at that point in time. So that the adults received 1,000 shares and the children received 500 shares.
Just for those of the gallery and those watching online who might not know where Lake Tyres is, could you just explain in terms of where it is in Victoria?
Well, Lake Tyres is situated what was known by the Crowatungalang people as Bunyanda, and it was the people, the Wanagati people, were the actual people of Bunyanda at that point. And that is the place where the missionary in the day, when the 90 or so people who were left of the Gippsland tribes, the Gunai-Kurnai, which were 5 tribes, the Crowatungalang, the Braburilang, the Tatangalang, Brayakallang and Braburilang. So they were the five tribes of the Gunai people, and Gunai-Kurnai people is also what we call ourselves now. So that's in East Gippsland. It's on the coast, and it's also a very significant country in terms of it's part of the water country of Gippsland. So you've got lots of rivers and lakes, and it's at the foot of the mountains on the Great Divide. So it's also a very important place in terms of its significance to our people as a camping place, a ceremonial place, and a place where people came to seasonally, particularly for fishing and hunting at various times of the year. And because of the climate, it's a very nice place to live. It's where I live today, actually.
Thank you. Now, you mentioned about people being forced into nearby towns. Just could you just help the commissioners with what the names of some of those nearby towns are?
So people were, after living all of their lives and generationally on Lake Tyers, at that point people were helped to be moved to the local towns. That was Bairnsdale, Orbost, Latrobe Valley, which at that point in time was a significant industrial area in mining, and that was where a lot of people were being moved to, even from the slums of Fitzroy. People were being taken to the work centres, of which the Latrobe Valley was a major work centre in Victoria. There are also people who were sent to places like Stawell and other country areas around Victoria. At that point in time, I know from family members who were part of that dispersal how they were told that they were going to be living somewhere else, and so all of their possessions, what they had, were packed up, and they were supplied with linen and cutlery and the household needs to move into a town. And so I'm not sure what the numbers of people that are actually removed, and I can't actually recollect exactly how many people were there at Lake Tyers when the Land Act came in. But it was significant enough to have an impact on the separation of families who were moved. And these were people who had lived on a mission and a reserve all of their lives, and then to be put into a town, a white town, at that time was devastating. I was actually growing up I was born in Yoorrook, which is the mining town in the Latrobe Valley. My father left earlier than that point, and he'd left, as a young man, and he gained work in that mining town in Yoorrook. And so we had a lot of relatives who were actually put into places around that area, and people struggled. They struggled essentially from the racism that they were confronted with to begin with, but also struggling because they were in an alien environment that to what they were used to, living on a place like Lake Tyers where they were isolated and then put into, major towns in Victoria where they were treated not very well.
I just want to ask you a couple of questions about that. Firstly, you said people were forced to leave. The people who were living at Lake Tyers didn't want to go.
I think coercion's probably a better term. It was waving the carrot of a better life. I actually got to meet the manager, the last manager at that, who was her husband was Len Rule, and this was Mrs. Rule that I got to meet when I first went to Lake Tyers to work in 1991, and she was an elderly woman then, and she actually told me that that's what they did. She helped those people pack up and move to those places. So, and that was the coercion, that people would get jobs and they would be able to get a house and their kids would go to school and they'd live like everybody else in those towns. But the sad reality is that very few were able to do that. So a lot of people, families separated. There was little work that they were able to get. The children, didn't fare well in the schools at that time. And I actually seen that from another perspective as a young kid growing up, and I was allowed to go to Maui or Morwell on the bus when I was about 14, and just seeing, incidents that were shocking to me, to see that people being treated on buses and in towns.
And it may sound like a silly question, but on Lake Tyers Reserve, people were in a position of being protected and in company with other community members and family. It was a safer place to be than out in the
Well, I guess the people who
reserve.
were left were those who chose not to go, and older people chose to stay.
Okay.
So I can't tell you what the actual selection process was at that point, and how people were identified. So I'd say there was consent to go.
Now, this process commenced, I think you say in your statement, in 1962, and then there were protests which followed in Melbourne.
In 1963, as I understand.
And how are you aware of that?
Well, I was about 9 years old at the time. I wasn't really aware of much else than my own little town and family, but I remember grandfathers and uncles coming in to visit us on occasions, and they were on their way to Melbourne. And these were the men who were going to Melbourne, and they actually got there via a local farmer, who had a truck, and he brought those men down to go to Melbourne. And on their way, they stopped at my parents' house for a cup of tea and a visit, and that's how I actually remember those men. And one of them was my grandfather, and we just loved seeing them anyway. But we didn't understand at that point what they were going for. But they came to talk with my father and visit with us.
We have a photo from your statement. I might see if we can have that on the screen. Do you recognise that photo?
Yes, I do.
And can you just describe who's in the centre of that photo?
In the centre is Sir Douglas Nichols, and on which side is it? The right-hand side is Pop Laurie Moffat.
And there are some other people in the background.
I can't see that, and I think we had that discussion. I think that person was identified as Joe McGuinness, and we're not sure whether that was the man that came from Queensland, or whether he was the Joe McGuinness that we knew, Graham. And I don't think it's.
I think so.
No, I think it's the man that came from Queensland.
And the banner says Lake Tyers Aborigines.
Lake Tyers for the Aborigines.
For the Aborigines.
Yes.
And so those are the men that you recall seeing at your house visiting?
One of the men in particular was grandfather Con Edwards, who was our grandfather, and he was married to my great grandmother, Julia, and his son was Ron Edwards, and I'm not sure whether he was there or not, but certainly Con was one of those men with I can't remember his name, Pop Foster. There are other men there that came to visit us, and Mullet, Uncle Pop Jim Mullet as well.
And you've said that as a result of those protests and the activism, the Aboriginal Lands Act was passed in 1970?
Yes, and that applied to not only Lake Tyers but Framingham as well.
And in essence, that legislation provided for a committee of management to manage the affairs of the trust?
That's right.
Now, you've had some role in managing the Lake Tyers Trust, have you?
Yes, in 1991 I was the manager at the trust for about 4 years at that point in time. Prior to that, I was actually a field officer for the Aboriginal Legal Health Service, who was looking, from the health service point of view, to looking at providing dental service and health services to Lake Tyers.
Are there any observations that you can make about the the experience of being on the land trust, and the way in which the government was involved in the management and upkeep of Lake Tyers?
Well, in that time, in 91, when I went there, the previous manager had passed away after being 12 months in the position, which was, he was a local man as well. That was the time of CDEP as well. So that was a working community, and there was about 200 people living there about that time. So it was a vibrant community. I was a fairly younger woman then as well. So it was a bit daunting to go out to that community, but I was, I think when I went there and thought, this is a big job. And I actually went to my grandfather, Ronald Edwards, and said, I don't know whether I should stay here or not. What do you think? And it was him and his wife, Hilda Tregoning, who said, we want you to stay and we will support you. And so I had 2 young children at that time. I think they were 4 and 6. And so I took up that job and worked in that role for that time. I must say it was one of the best jobs that I ever had, in working in that environment. It was a rural community, and in the days of ATSIC, where everyone was pretty hopeful, I think, about the future. And certainly, there were strategies for, various communities. And the strategy that we chose, rather than arts and craft or anything else, was a rural industry strategy. So we went to ATSIC with that in mind. We were a farming community. So we produced cattle, and that was the main industry at the time. We had a farmer who, we employed people through the farm. But with the rural industry strategy, we also looked at becoming, growing chickens and other farm animals, I guess, as part of the strategy for economic development. We also realised that some of that was not sustainable, and certainly the cattle farm wasn't sustainable to begin with. And so it raised a whole lot of issues for us, which is what we were prepared to meet those challenges. And so it was about also looking after the land and looking after the bush and the lake, because the place is situated on a lake that's mainly sealed from the sea most of the year. And when that sandbar breaks, it's a time of big ceremony, and it's fishing. Fishing is the main stay of the diet of the people at Lake Tyers, and that's what most people did. We existed on fish. So there were all sorts of things that we wanted to do, and that was the aspirations at that point in time. We also employed non-Aboriginal people from town who were skilled in things like welding and other trades that worked with the men out there that were actually had apprentices and training people up in those areas. So yeah, we used to make our own cattle grids and all of that stuff.
You've set out the aspirations and some of the things that were done in terms of the strategies for Lake Tyers. Was that made easier or more difficult by the legislation, the Aboriginal Lands Act?
There wasn't a problem with that. That was, I guess, prior to ATSIC, it was managing the best that you could with, with what you had. And it was primarily a cattle farm. It was 1,000 acres pretty much cleared for of the 4,000 that was for the farm and for the community. So the farm took up most of that cleared land, and we had a farmer who was married to one of my cousins, and we had farm apprentices, and people were working to, we actually produced the best cattle in the country at that time. I have to brag a bit, but before that, the cattle were, there wasn't that same kind of management. So cattle were sort of just all over the place. But at the end of that, when the big drought in Queensland happened, we had farmers come down from Queensland to buy our cattle because of the quality of that stock. So there was hope in that, but it wasn't really sustainable. You couldn't really employ any more than 1 or 2 farm hands as well as the farmers. So with that amount of cattle that we actually could farm sustainably.
You're familiar with the term self-determination?
Mm-hmm.
Is the arrangement that exists in relation to the land trust at Lake Tyers what you would describe as an arrangement delivering self-determination?
It's fairly complex to sort of to assume that that's what it would be. That's what you would hope for, but the reality is that was in 1991 to 1995. Since CDEP finished, and all of that hope that I think that people may have had in ATSIC, and we did as a community, that's gone downhill to this point in time, which is it's in dire straits right now. So,
is the decision making left entirely to the community, or is there interference in that process?
So we had a period of time where we were under administration for 10 years, where the state government run the trust for 10 years, and in that time, there were a number of administrative changes made to the Act. It was totally run by the state government, and people felt like they went back to the mission days as a result of that. The buildings were, it looked like a prison farm, actually. I came into that position 6 months after that the finishing of of that time, and it was like, it was very strange. It was a strange feeling. We had fences put up, for example, that were prison green fences, aluminium fences, which were surrounding every house. It was a 6-foot high fence around every house. Today, those fences are falling apart because they're aluminium. They can't stand up to the wind, so they're falling over, and there's no resource to fix them up. So, and going into the offices where the offices weren't for the people; it was mainly for the staff who were working there. So there was signage up: you weren't allowed to touch this, and you weren't allowed to go here, and you weren't allowed to do that. So the first thing we did was take down those kind of signs and put some blue colour there, and just open up the doors again for the community to re-establish themselves as the owners of the land, I guess, which we didn't feel like that during the time of the administration. Yeah, it's been very difficult. It's been heartbreaking, actually, to see the disappointment, and particularly the elders that had hope at that point in time to see. And today it's even more serious because I guess the relationship with the state government, and it's been different governments, different, political persuasions, but it's been the same treatment that we've had about, for example, the share register itself. We don't even know who's got the original copy of the share register. So there's been management that's been happening that haven't had the people with the skills to actually administer or manage a community such as that. And that's been a problem, obviously, because to manage a community of 200 people with a land mass of 4,000 acres because you're running a town basically, with people with minimal skills to do that, that's going to be fraught with mistakes and problems, which is what's happening right now.
Does that community still maintain hope?
Well, I can honestly say from this point in time, and it was only from yesterday with more information, not very much. The fear right now is that we're going to go under administration, and a lot of people are actually wishing for that. I guess the fear then that if we go willingly under government administration, then, that sets us back again as far as the term self-determination, which I've forgotten what that means. It's actually relevant to me because I'm sick of hearing that word, self-determination, when the reality is it's self-determination according to the whim of government. And it's what we're allowed to have and what we're allowed to do. And I don't see any difference to that concept right now to what it's always been. And I'm living there right now today as an elder and seeing, people in despair, young people walking around. There's no transport to Lake Tyers. People don't have cars. A lot of people don't have cars. And the ones that do struggle to maintain them. It's 20 minutes into Lakes Entrance. That's the main town where we go shopping. So just to do that is a struggle for many people today. There's no public transport, and so people are reliant on others to get them into town. And most of the people are unemployed. They're on pensions. So it's very difficult. And for the young people, it's even worse because the school was closed down during the last 5 years, I guess, the local school at Now, where our children all went to school, that was closed down arbitrarily in the town of Now. And we had always had kids going to that school. Well, there's no school now, so some kids aren't going to school. And that's becoming an increasing problem. And when our young people go to school, living on the reserve is still, under the Act is still an Aboriginal reserve. And so the discrimination by people in town of us anyway is it's been negative. So more so now because, the situations that we're faced with.
Now, I might take a moment here and ask the other panelists if any of the things that Marge has spoken about raise issues for you that you would like to speak to the commissioners about. Are there any things that strike a chord with you and your own experiences? Uncle Graham?
Yeah, I've heard this story so many times. From the communities that I've been involved in, but Marge has given a really good summary of, the conditions and the struggles of having your human rights respected and the support for the community to develop in a sort of meaningful way that puts them on an equal footing with wider community. I was just reflecting on Marge's story about Lake Tyers and how people were coerced, was her words, to live on Lake Tyers. And it reminded me of my family and my ancestors' experience in living on, firstly, Maloga. That was the mission. That's on. That was on Yoorrook heartland, and then that was closed, and then was moved. It was moved upstream to Cummeragunja, and the discontent that arose in the 1930s towards the mission management method of really oppressing and repressing people on those missions got to a point, and this is in 1939, where the community, and this included my ancestors and elders of my extended family and my parents, they just walked off, and it became known as the walk off. And like Marge said, they walked off, and they had just got fed up with sort of living under a mission management style of organisation, and they too had to disperse and find suitable employment, accommodation in the surrounding areas, in places like Shepparton, in the Goulburn Valley.
I can just stop you for a second. You mentioned the mission management style. Just for the Commissioner's benefit, what are you referring to when you're talking about mission management style?
I'm referring to what Marge said earlier about the people living on these missions. My ancestors weren't allowed to practice their culture. They weren't allowed to speak their language. In fact, they were punished, rations held back. And if you look around some of the missions throughout Victoria, it was a common practice that and it was referred to as mission management. And most people that found themselves living on those missions or reserves, they became very discontented and dissatisfied and wanted to look at better alternatives. So it was an oppressive regime, Tom. Sorry, Tim.
Tony.
Tony. Yeah, and I can relate to the stories that Marge has just shared with us, because you can go just about to any mission throughout Victoria, and there were a lot of missions that were set up, and you could sort of find similar experiences of the residents that were confined to those situations. Yeah, so yeah, I can relate to what Marge has shared with us.
Living under those conditions, does it have an impact on people's identity and self-image when your culture and way of being is oppressed, I think is the word that you've used?
Yeah, look, I'd even go so far as to say it did impact on people's self-esteem, self-image. Because there were very limited alternatives to that sort of those conditions. It did impact on people, I believe, psychologically, emotionally, and and stories that I got from my parents. Both my parents lived on Cumbregunja Mission, and they shared stories with me, on stories of, the terrible conditions that they lived under. And yeah, we're only too glad to leave the mission, when the time came.
Karen or Julia, is there anything that you would add to those observations?
Yeah, I wanted to say I remember that time of hope in the early days of Lake Tyers. I remember being really excited because you were doing like brick making work down there, and I just went, "That's phenomenal! This is an amazing community doing this, really strong work and being strong in community." And then you also had the cultural dance groups and those sorts of things. And then when things fall away from that strength and that hope, you can see, land without capacity, in the ways that blackfellas need it, has a really big impact on community cohesion. And people end up, and they are marginalised and erased in those spaces, which fractures people's identity and well-being and belonging. And I see those things also happening to the Aboriginal community in the west of Melbourne. But they haven't been quite as hopeful, I think, as what Lake Tyers has been. But that's, it's the things to sort of hold on to. I think that we can do that work. We can be strength-based and grow in those spaces.
Without putting words in your mouth, are you saying that with the right resources and the right conditions, great things can occur?
Exactly. Yeah.
Julia, anything you wish to add at this point, or?
I took just a note, and the thing that just popped out to me is this idea of coercion and and this idea of silence, and how we view history, as more and more stories and histories are being told. The evidence of coercion is becoming much more clearer, and it becomes it can become really about people's understanding of what coercion is, and matters of choice and stories of experience. And so I'm very aware of the language that you've used, Auntie Marge, to describe these histories and these stories. And I think we should take note of that description.
A form of dealing that government has with Aboriginal people that you've observed in other places?
I think
circumstances.
I think that it's a form of dealing which amounts to an opportunity of choice. And when people aren't given multiple choices to control their lives and to make decisions that are the best for their family, singular pathways are created, which means that impact generationally on families and young people, exactly what you've described, and exactly what you say when we're talking about, can we put coercion and self-determination in the same sentence in Australian history? Probably yes, we can.
And some of that, the impact, the psychological impact that people, perhaps your parents, Uncle Graham, experienced, people who have been part of the reserve system, the mission system. Do you have any observation as to whether that flows through the family then after that point?
Oh, look, it's transgenerational. It was transgenerational. Like the irony of this is that some members were able to survive the mission management mentality, and when they were able to move away, they still kept in touch. They still, through their social interaction, they still were able to support each other that way. So it would, was often, more than one family who'd move off the reservation. They also settled in the townships. For example, I talk about Golden Valley, Shepparton, Mooroopna, places like that. And those areas became smaller communities, but at the same time, they become fringe camps too. Like, the flats at Echuca between Shepparton and Mooroopna, where the local communities, they shunned through their racism. They shunned Aboriginal people settling in those townships. And it was just through their persistence, this is, my family, their persistence that they were able to find work, find accommodation, and, then support their families. I'm from a family of 7, and my parents, they had the work ethic, and it was through that they were able to survive, and and there were other examples of that too, with other families that decided to better themselves and move away from the mission. Yeah, I hope I answered your question. I might have.
Thank you. Whilst you're talking about that part of the world, I might ask you some questions about the period around the Mabo decision and what flowed. It's a case, isn't it, that before the Mabo decision, you were involved in a claim made over the Barmah Forest. Can you just explain that for the Commission, please?
Yeah, look, goes right back to the 1880s. The Yorta have persistently strived for the recognition of their need for land, the recognition of their land justice or land rights. And back in the 80s, the mid 80s, the Yorta organised itself to lodge a claim with the Kane government, and that was to regain the ownership of the Barmah Forest and also the Millawa Forest, and there were other reserve areas along the Gungulla Murray River as well. That was lodged with the Kane government, but it didn't succeed. So,
but this was in the 1980s, you said?
Yes, in the 1980s. And
during the period while there was a Labor government federally?
Kane government was in power, state government, and the Kerner government, but it didn't succeed. And so then coming up to the Mabo decision, that the High Court handed down in 1992, the Yorta saw an opportunity there to have their rights and interest in land recognised. So 2 years after the Native Title Act, a year after the Native Title Act was enacted, that was 1993, A year after that, in 1994, the Yoorrook lodged the first claim, native title claim in Victoria. And that was lifted people's spirits. The feeling around the community then amongst the Yoorrook members was that, hey, there is a possibility that we might have a positive determination made by the federal court on our claim, albeit, as you know, 1998, Justice Olney issued a negative determination on the basis that Yoorrook rights, and it was all contained in our native title claim. Tide of history had washed away our rights, and therefore had extinguished our native title rights. Full stop. And then, as you know, the Yoorrook didn't take that lying down. They first lodged an appeal to the full federal court. Same result. The appeal was dismissed. And so, and you'd know this, Tony, the Yoorrook organised themselves, and all this time I was on their governing committee, and my brother, Dr. Wayne Atkinson, and I were all the way through these claims. We were staunch supporters of each of these claims that up until then were not successful. And then in 2002, High Court dismissed the claim. So that's not the end of the story, but I'll come back to this later. Yoorrook then had to go down the path of, and that was when there was a Labor government had come back into government, and Rob Hulls, the Attorney-General, he offered to the Yoorrook a co-management arrangement of the Barmah Forest and the other surrounding forests that were part of the Yoorrook heartland. So that was done, I think, in about 2004.
Can I ask you a question before we move on? Looking back now, what effect did the High Court decision have on the Yoorrook people?
Oh, a tragic effect. I can remember how it impacted on. They were devastated, and just in my own situation, I was. We were devastated. Dr. Wayne Atkinson and I, who were part of we were applicants in that claim. We were just shell-shocked and devastated that, we went through the right process, hoping to get land justice, only to see our aspirations just not supported by the state government. And the irony of this also, Tony, is the state government prior to 2004, that's when the Labor government came back here into power in, I think, 2002. But they were respondents to our claim. That's the Yoorrook claim. And I sat in those hearings that many times, and I couldn't believe what I was seeing. You know, the state government, represented by their legal team, opposing our claim, and they succeeded. But I guess I don't know whether it was guilt or shame, but when Rob Hulls came into the position of Attorney-General, he took a more sympathetic approach towards the outcome of that devastating decision of the High Court.
Now, the Yoorrook people have had a number of knocks over the years, and always got back up. What can you say about what's happened since that time?
Look, some positive things have emerged. I said a moment ago that the state government, supported strongly by the Attorney-General, who was Rob Hulls at the time, he offered the co-management arrangement of the parks where Yoorrook could be involved in the management of those park areas and the waterways. However, it was a co-management arrangement. It didn't mean that the Yoorrook received Aboriginal title to those areas, and that is the distinction between co-management and joint management, which joint management, where those traditional owner groups achieve that, they also receive Aboriginal title to those jointly managed parks.
Do you see that as an important aspect of the management? Is having Aboriginal title an important aspect of the management?
I think it's the only way to go. It's the only way to for the government to demonstrate that it's serious, it's genuine about giving traditional owner groups the power of self-determination. And that's where I see that as being an important part or element of joint managed arrangements, parks, and so on.
I'll just hold you there for a moment, and I'll come back to some more questions about this topic. I just want to ask the other panelists about their memory of how the rest of the Victorian First Peoples communities felt on hearing the Yoorrook decision and the loss of that case. Would anybody like to comment on that?
Devastating. It was devastating, and I think that to see that happen to the Yoorrook people was, you know, of concern to other groups about how they would fare. But I think we were quite naive when we went into this native title process, and I think that the legislation in itself is flawed from the start, and it doesn't really address the needs of the First Peoples in this country. And I think it homogenises our people to a point where we're losing. We're losing aspects of who we are, where we come from, our culture, our connections to country. And, we're the Gunai Kurnai claim. I don't know whether we were the next scab off the rank, but we have the co-management of parks in Victoria, and there's still concerns about what rights do we really have in protection of country through that process as well, and we've got issues there. And it's also about Gunai Kurnai. It's disregarding that there are 5 tribes of the Gunai Kurnai peoples, 5 tribes that have language boundaries, territorial boundaries, and so that's just been all wrapped up in one group of people. And I think that takes away the essence of who we are and what we're about as people of the land, and the connection that we have to particular parts of that country.
Thank you for that observation. I might just ask Karen whether you had what your feelings about the decision affecting your people was.
I was really devastated at the time too, and I still get emotional when I remember that time. I was there when the decision was handed down, and I just couldn't even contain myself. It was just so much horror and pain in that decision. I got in the train and cried all the way back to St Albans, thinking, what the hell just happened? That can't be right, because Yoorrook so strong, and Yoorrook has always had connection. And Yoorrook mob are everywhere, and we talk about country, and we're connected to that space, and we know that space. It was, one of the worst days of my life. And it was just a real shock for that to happen based on white man's story, not black fella's story, and all of that telling of connection and belonging.
Do you have similar feelings to Uncle Wayne in terms of disbelief that the state could do that to your people?
Exactly. I think everybody just believed it would be a winnable case, because we all believed in the strength of Yoorrook, and we've all been connected to it. But I guess also, it was hard to believe. The other thing too, I guess, around native title and that whole legislation is that, what you have to give up to actually go down that path is probably not a good path to go down. If you have to extinguish your land rights to have native title, and you don't get the capacity then to use land in the way that you should, in the way that you own it inherently, then it's not a good process either way, even though it was devastating for the response that we got.
Julia?
The only thing that I would add is that the case setting a precedent for other mobs to follow, and the burden of proof of community to show ongoing connections just presented a really repressive authenticity that was reliant on community to prove who they are, and it's the way. It's always the way. The burden of proof is always on community to tell story, to educate, and to prove ongoing connection and rights to country, and doesn't take into account the legitimacy of the state. It's just,
But that burden on the community to prove itself, you're criticising that?
Yeah, because people have inherent rights to land and country, ongoing sovereignties, tangible and intangible heritage and culture that has been maintained in various forms by even if it's exile or survival, in all these different ways that actually haven't been controlled by the state. But in seeking to control these repressive, narrow ways of being are enforced on communities to perform in a particular way in the hope that justice might be served.
it's that method of controlling people's access to rights and power. Is that something that you've seen before, or you know of from different aspects of your research?
I have come across, yes, yeah, from my PhD research in Western Sydney and the Blue Mountains of people trying to seek belonging and legitimacy through the state. And of desperately trying to prove connection to country in the eyes of the state and in the eyes of scholars and anthropologists and historians, seeking other people to determine and legitimize stories. And, there's a huge stories around movements in and out of place, movement to and from community, in and off country, other Aboriginal people moving on to countries of other folks, and being in better positions to speak to government and can move in a particular way that other families weren't able to. And all of this is a result of the state and colonisation and how people decided to move through these processes. I was talking to Uncle Graham, when we were having our Zoom, and I was saying, I always think that people who have control of family, self and country stories have a really, have deep cultural wealth that enables people to be well. And not everyone has that cultural wealth that they can draw on, that fuels the energy to keep fighting against the state and other people.
Thank you. Turning back to you, Uncle Graham, there was an Aboriginal land rights claim under the New South Wales Act in relation to the country under the New South Wales legislation.
Yeah, because the order don't abide by boundaries, state artificial boundaries. So their country straddles both the Victorian and the New South Wales side of their ancestral land. It's interesting because there was some interest after New South Wales had passed its Aboriginal Land Rights Act. There was some interest that was actually shown. There was a bit of a ripple effect that resulted in groups like Yoorrook and others sort of putting pressure on the state government to also introduce a Victorian Aboriginal Land Rights Act. But that got blocked by the state government. It didn't go anywhere. And time then sort of moved on, and Mabo appeared on the horizon, and the Native Title Act, and the claims that were lodged. I just want to say here, though, Yoorrook have never ceded their land. That needs to be understood. We have never ceded our land to anybody. And we and other traditional owner groups would echo that same feeling. You know, we shouldn't be asked to prove that we have connection to country. You know, that we have the right people for country, and all that was tied up with the, you know, with the hurdles that you had to get over in the Native Title Act. It only took Justice Onley 1 minute. 1 minute, I was there. 1 minute to hand down his decision that just sort of swept away our rights. But Yoorrook still is persisting. It hasn't given up the fight.
I just want to ask you a question about the ceding of your land, and you've heard the expression that sovereignty has never been ceded.
That's right. That's what we mean. We have never ceded sovereignty to our tribal land or ancestral land.
If the state or government agencies say, well, we acknowledge that sovereignty has never been ceded, what should they then do if they're prepared to make that acknowledgement?
Well, there's a lot of unfinished business that it opens up that whole question for the state government to come and say, look, I recognise your sovereignty. There's your self-determination. You can't activate that without resources, and that would include compensation. You know, meaningful, reasonable compensation for the damage and the destruction that has been inflicted upon traditional owner groups, not least the Yoorrook. And but other traditional owner groups would echo that as well. You can't. It's very hard to get back on your feet if there are no resources that are provided to help you to then realise that self-determination in practice.
Do any of the other panellists wish to comment on that particular point?
Well, what Graham is saying is right, that we've not ceded our sovereignty. We assert that we are the owners of country, and the state government won't listen to that. And so there's always this pushback by them to comply with their wishes, and it's usually via resources. So, and we're a poor people who don't have resources. So it's very difficult to say, we don't need those. But what is happening is our rights are being eroded continually, particularly, we had a successful native title claim, Gunai Kurnai, so-called successful. But one of the things that we managed to do from the outset was establish an elders council above the corporation. There's problems with corporation laws that don't fit into our way of thinking. And so when we're talking about what we want and what our needs are, it's about our spiritual connection to country, which means, sites that we know of and we need to have as part of our ongoing well-being, that we need to have access. We need to control those places so that they're the places that how we stay well if you like, and connect it. And you only have to look at the, statistics today, which are shocking. They're shocking right across the board, from people who are in jail, people who are dying in custody, people who have been removed from their families, people who are, being disadvantaged seriously in this society because we don't have the capacity to deal with what's being, put on us. You talk about us getting our native title claim, but we have joint management, but we're not allowed to say no. We're not allowed to say no when we see mining pits happening in the middle of the bush, for example. And right now, we can't say no to burning, which we know is just another way of extraction of a resource, which is the timber resource in East Gippsland in the forests, where the logging is supposed to have stopped. But we see logging trucks going all through Bairnsdale every night. And the part of that we know that, everyone wants a job, and those people who were dependent on that logging industry now have all of this gear that they don't know what to do with. They've invested heavily in it. So one of the things that we see now happening is fire management, which is shocking right now. And what they're doing when they're saying we're doing cultural burns, it's rubbish. It's absolutely shocking to see what those cultural burns are doing. They're putting roads through forests, which create tunnels for wind channels. When a fire comes, well, it's all over. We're talking about burning coastal forests, which have never had fire history, never been burnt. And, the destruction of habitats of animals, which are our totems, but also our sites. This is what we're told. We went into the agreement of joint management, but we don't get to say no about these are areas that you shouldn't burn. These are the areas that need protecting because they're very important places, and that's in our stories, that these are important places. And there's no understanding or total disregard by those in power. Sadly, we don't have control of those native title bodies. They're controlled by lawyers, native title lawyers, who have made a nice living off our backs and off our land. And so it's very difficult to deal in the native title arena. And, I can say that from my experience in the Gunai-Kurnai claim, but also in the Eastern Maar claim, which is going on now. It's not good. So we're subjected to this trauma of having to continually say, well, this is not right. We need to have a better deal here, a fairer go about what we're talking about when we're saying what happened to our people was almost total annihilation, as it's been said in Victoria particularly, where it was wholesale killing off the blackfellas because of the thirst for land, the hunger for land by those people who came here. They had no qualms about murdering us outright. So the plundering, the rape and pillage of our people in those early days is still felt today. The fraction, the children that have been removed and the people who've been dislocated is just horrific. And we're still trying to recover from that, and it's ongoing. So where is the justice in that when you're talking about this is our country, this is our land, we want a better deal, we want a fair deal. It is more than compensation. It's about reparations, because what was taken for us needs to be restored as best as we're able to. And we talk about management. Well, it's not corporate management. It's not white man's law about making money, because that's really what corporation law is about. We're talking about law that looks after the people, all the people, doesn't matter who you are, and looks after the land, which is essential. And I think that's what you see in other countries in the world, where you don't destroy your land. What other countries in Europe, they don't destroy the land like they do in this country? And I think it's because the white man has no respect for land, only what he can get out of it to make a profit of it. Whereas the blackfellas don't have that way of thinking. And what we're trying to do is survive with integrity, about our cultural values and our understandings and how we treat each other. You know, there's some of the values that we have to offer in this cruel world, I suppose, of where it's all about money and not about people. So, you know, that's what we're seeing. We're seeing, you know, you only have to look at cities like this and the homelessness in the street and the desperation in people who are in, you know, terrible circumstances. What our people did on those reserves was look after each other, as bad as it was. That's what we always held as part of our integrity as human beings, was to take care of people and take care of the land. That's the fundamental foundations of our law. And that's what we understand that's our obligation. Not about rights or anything. What are our obligations as first peoples of this country? That's what it is. And that's not reflected in what negotiations with the state is hard, cold, you know, legal technicalities about whatever. And so when you interpret that about what you actually get, you know, we're having this battle with the native title bodies about destruction of sites right now. And they don't have much of a say because it's all about the contractors that are employed aren't Aboriginal, or even if they are Aboriginal people, they've lost sight of what the essence is about what we're talking about is, this country and what it should be.
Thank you very much for sharing those insights. I have kept you a little bit longer than I intended. We ought to have had a break before this, and I might ask the Commission if it's now a convenient moment to take a morning tea break. 15 minutes, is that sufficient?
We want to do it. 15 minutes. Okay.
10 minutes, really, to 15.
10? If the panel is comfortable with 10-minute break.
Yeah, that's fine. Yeah.
So, Commissioner Chair, at 12:05. Thank you, Chair. It's my intention to finish with this panel by approximately 12:45, which will leave some time for a lunch break. The Surveyor-General is scheduled to commence evidence at 1:15. I can indicate that in the circumstances of the lengthy session this morning, I would intend to commence him at 1:30 p.m. so that there's a 45-minute break for lunch. However, I'm in the Commission's hands on that matter. Now, before the break, we heard some evidence about the Yoorrook native title claim, and then some evidence about the Gunai-Kurnai native title claim and the outcomes of that. I'd just ask Uncle Graham to perhaps let the commissioners know about his experience in the Judge Warren process. Yes?
Yes, okay, yeah. Just as a segue into that, I just wanted to also say that after the Yoorrook case didn't succeed, there was a really strong feeling amongst traditional owner groups here in Victoria about whether any claim would get up. And that there was a lot of cynicism, scepticism around the traditional owner community about that. In 2003, there were two things that happened. Labor government was elected in 2002, and you had new ministers coming in that were still reeling from the Yoorrook decision, and really felt that they needed to do something to mend the fences, so to speak. And Rob Hulls became a really good ally of the traditional owner community then. Also, it was as though state government was wanting to make up for their success in contributing to the negative determination against Yoorrook. It was as if they wanted to, overcome that and mend the fences, so to speak.
If I can just interrupt for a second, you were right in the centre of that as the chair of the Native Title Services Victoria, I think it was.
That's right. And the second influence, I guess, was in 2003, just bore that, the Native Title Representative Body, then known as Murrumbidgee Nations, Clans Aboriginal Corporation, lost its representative body status. It was deregistered. So something had to be done to fill the gap. In 2003, the Native Title Services Victoria was established to fill that gap. And not long after that, I was elected as the chair of the organisation. So this was in 2003. And my board, and the chairperson was also on that board, Eleanor, and others, we needed to look more closely at whether the Native Title Act was the right vehicle for settling claims. So in 2003, from then to 2005, that was a critical period because the Watchaballock claim was already in the pipeline, and it received a positive consent determination. So that was the first, 2005, that was the first positive consent determination that was achieved in Victoria that benefited the Watchaballock and also BGLC, who became the traditional owner group entity. Another interesting development occurred around about that time, because there was still a lot of talk about whether trying to get the Native Title Act to settle your claims, there was still a lot of scepticism and discontent about that being the vehicle to settle claims. The traditional owner community, you could say, came together with the support of Native Title Services Victoria, and in 2005 saw the establishment of the Victorian Traditional Owner Land Justice Group, also known as the Land Justice Group. And it comprised of representatives from 21 traditional owner groups throughout Victoria. And it also pushed the government, and in this case it was the state government, who were now supporting our concerns that the Native Title Act, which required a litigated settlement of a claim, they were looking at an agreement, an alternative agreement making process. So the Land Justice Group agitated for an alternative system to settle. At that time, I can't remember it off the cuff, but there were several, including Marge's that you mentioned before, but there were several native title claims on foot. It was taking an average of 20 years for there to be a settlement of these native title claims. But the Land Justice Group continued to go down the path of supporting a non-litigated process through the federal court and adopting a agreement-making process or alternative agreement-making process, which entailed the traditional owner groups negotiating directly with the state government on the settlement of their native title claim, as opposed to relying on the federal court structure to settle a claim.
Just before you continue, I just wanted to ask, you said that the native title claims were taking an average of 20 years.
Yeah. Or more.
Or more. Is there some effect that upon the community from being involved in this sort of litigation for such a long period?
One significant downside, and I saw this effect with my own eyes. Some people didn't make it. They didn't last the journey. You know, our elders, many of our elders didn't see positive outcomes, and that was, excuse me, that still chokes me up today. No, good people that put their shoulder to the wheel to win, to gain our, our rights, land justice rights. Didn't last the journey. And I still think about that because it's a very emotional one. So in answer to your question, Tony, there were quite a number of people who dropped off on the way because of ill health or because of age. And the journey is a very stressful journey. It takes a lot out of you. And I could see amongst people who were part of that journey, I could see the stress and the struggle they were having. But we...
Sorry, did some people find that traumatic, being involved in the litigation, do you think?
Oh, yes. Yes. And we rallied around amongst ourselves to support people that were, traumatised, or because just jumping back to the trial process under the federal court, these people were put in the witness box and they were cross-examined about their identity, and it was it was terrible to see the pressure. That was traumatizing. I saw that with my own eyes because I sat in on most of the hearings, and I can still remember those experiences, and but we didn't have. Well, we had Native Title Services Victoria, which then I became the chair of. We tried a more proactive approach to settling the claims, and we tried to fast track and not have the process bogged down with legalese or lawyers, and it was also costly, a very costly process. So we, in a way, provided support to TO groups across Victoria on managing their native title claims. And as Marge said before, Gunai Kurnai, after Watchaballock received a positive consent determination, then there was Gunditj Mara or Gunditj Maring, a positive consent determination. Mind you, this is 2 decades after the introduction of the Native Title Act. And then in fast forwarding forward, then I think it was about 2010, Gunai Kurnai got their consent determination, and it was an interesting claim. It was a hybrid claim that Gunai Kurnai took to the federal court under the Native Title Act, but it also used the newly established Traditional Owner Settlement Act to also enter into an agreement with the state government directly. But
I might ask you if you can just explain for the commissioners your view about the Traditional Owner Settlement Act now. I'll move to that.
Yeah, look, I'll try. The Traditional Owner Settlement Act, it was an alternative agreement making act. That is, it didn't have to go to the federal court to be litigated. It only required you to organise your traditional owner group to negotiate directly with the state government on your agreement area. And what you were trying to achieve was what came out at the end of the process, a recognition and settlement agreement, an RSA, as opposed to a consent determination. Now, the Land Justice Group, when it did its consultations with the wider traditional owner community, it never presented the Traditional Owner Settlement Act as an either-or outcome. It came down to a choice which the traditional owner group could make, and some of them chose a hybrid model. That is, they chose to continue with their native title under the Native Title Act, but they also chose to take advantage of the Traditional Owner Settlement Act. And that's what Gunai Kurnai did. And they were able to get settlement of their claim in 2010. The interesting part here, Tony, is that my group, and I just need to fill in a gap here, after the outcome of the Yoorrook claim, the learnings that I gained from that, I didn't want to see that experience repeated. And with my Judge Abarung identity, I was asked to get involved with the Judge Abarung claim. Now, Judge Abarung claim was lodged in 1998, 1999, and sadly, that claim, a bit before I came on the scene, that claim, that was only for 4 small parcels of land, and that was part of the Future Acts process. Those claims didn't pass the registration test through the National Native Title Tribunal. So when I got involved with the Judge Abarung, we said, look, and we agreed, and that was under the auspice then of the previous body, that is Murrumbidgee Nations Aboriginal Corporation. We need a better representative body in place to support us in this claim. So we were able to achieve that, and hence the Native Title Services Victoria came on the scene. I was appointed as the chair. That was a position that I held till I stepped down. I chose to step down in 2014. But the in 2008 to 2009, the Land Justice Group negotiated with the state government then, and that was with Robert Hulls, who was the Attorney General, to look at establishing a better system than the Native Title Act. So he engaged Professor Mick Dodson, and Mick was appointed as the chair of a steering committee that Rob Hulls set up, and it was a steering committee to look at the establishment of a native title settlement framework policy. And this was a really important outcome of that steering committee. The people that sat on that steering committee were, I think it was 5 Land Justice Group reps, and they were chosen from the Land Justice Group itself, its membership. And there was also a negotiating team from the state government of the various agencies that were part of that, including, Department of Justice and other agencies. The 5th position was then occupied by the Chief Executive Officer of Native Title Services Victoria. So Mick Dodson chaired that meeting over 2008, and at the end of 2008, he presented his report, and the title of that report was Native Title Settlement Framework Policy. The push at that time as well from the Land Justice Group was we needed our own act, state act, hence the Traditional Owners Settlement Act. And that was the act that traditional owner groups could go to or use to settle their outstanding claims. Now, many of these claims, as I said before, were on foot for, some 20 years or more. So both Houses of State Parliament, with the support of the Land Justice Group, passed the Traditional Owner Settlement Act in September 2010. The first people to take advantage of that act was Margis Group, the Gunai-Kurnai, but they were also continuing with their Native Title Act. So that's where the Jaja Barung also joined that queue or became part of that process. And with the support of Native Title Services Victoria, we were also then able to manage our recognition and settlement agreement directly with the state government. And in March 2013, we signed that agreement with the state government.
And I think in your statement you refer to the recognition and settlement agreement process as perhaps forming a high watermark in terms of settlements for Victoria, at least.
Yeah.
And when you say that, you're referring to those settlements that include the Jaja Warrung?
Yes. It was it was the first comprehensive settlement because it sort of included the detail of the various agreements that came under an RSA, such as a land management agreement, a land use activity agreement.
Are you aware of how many recognition and settlement agreements there are in place at the moment?
I think there's 7.
And is it your view that there should be attempts to enter those types of agreements wherever the traditional owners seek them?
Look, I have to say here, and I'm prepared to go on record about this, I'm dismayed that our Native Title representative body isn't doing more. I think it is incumbent upon First Nations, legal and research, they're the representative body, were once badged under Native Title Services Victoria. I'm amazed that they are letting these opportunities slip through their fingers and still persisting with the Native Title Act. Now, I know also that there are some traditional owner groups that are looking at both the Native Title Act and the Recognition and Settlement, the Traditional Owner Settlement Act. Look, I went to the Eastern Maar determination that was done last year, and it was a look. It was a I come away with mixed feelings. I was really pleased that they had their land claim recognised, their native title claim recognised, but it was for only 80% of that claim area. They still have to go back for the other 20%, but they have to go back through the federal court system, which is a trial, to gain the other 20%. And what came out of that, what startled me when I attended that event, was they've been working on that for the last 20 years. And why does it have to take that long to resolve these, these claims? Something is wrong. Something is not working So, I'd have to say I'm less an advocate of the Native Title Act, more an advocate supported by my land justice group colleagues of the Traditional Owner Settlement Act.
I gathered that.
Yeah.
Do any of the other panelists have any comments they'd like to make about the Traditional Owner Settlement Act?
I guess, with disillusionment of our people going through this long drawn out process is obviously very stressful, to say the least. And I think part of what's missing in all of this, that people aren't and don't have the opportunity to be fully informed about what these what the legislation actually means in the long term. So it seems to me that this is all about making a deal for access to land and resources. And I don't believe that our people have been properly informed or understand exactly what this all means. It's quite technical legal stuff. And from day one that I've been involved in this, I've actually, been disengaged and disappointed and all of that, and got back onto the Eastern Mar claim because, of the issues that I see there that particularly have left out important matters that should be dealt with before you even go into those processes. And the Eastern Mar claim, they're quite aware of my objections to that. But without going into the blame game and what's wrong, what I see is not happening is that what I just mentioned is that people aren't properly informed or understand exactly what this all means. And also our people, because this has been offloaded on elders' shoulders. You see this cherry picking for, the oldest person. Well, sadly, with that responsibility on their shoulders, as Graham says, they're getting really, they're dying as a result of the pressure that's been put on their shoulders to actually, play that role. I don't believe that, in my experience, and I could only talk about the Gunai-Kurnai and Eastern Mar, I don't believe that there's been enough effort by government, whether it's state or federal government, about making sure they're talking to the right people. And that doesn't matter how old those people are, but it's about clan groups. It's about people, who have that right. And I know it's quite complex, and particularly so with people who've been dispersed, people who've been removed. That's something that we're still grappling with right now. But I think that the people who have always been on country and held on as best as they're able to their knowledge and their connection, it's those people that have been, sort of pushed to the way kind of for convenience. But I reckon that those people are the ones that really need to be, because these are the younger generation as well, who're going to have to carry this through and improve on it and deal with the fallout from all of this disappointment, because the disappointment is ongoing. You think you've got a native title claim and you've got some land. You don't have any land. I live on a reserve that's surrounded by forest that we're told is ours. The first thing they did was change all of the tracks in Lake Tyers Forest. You can't make your way. The traditional track going through from where we used to take into Lake's entrance is gone. It's not there. I can't even find my way around that forest. And they took the bridge out. So it's always changing the environment, if you like. But it's also access to sites within that forest that you don't have. It's protection of those areas as well. It's not happening. And that needs to happen because you need the young people and the people and you need to be able to welcome back people who've been lost for whatever reason There needs to be that society that you continue your culture. It's no good having a culture if no one knows what it's about. And that's what's happening, I see out there. And that's disappointment, I think, that the old people, most of them are gone now. You know, the generation of, you know, elders sitting here is, you know, it's left now to the young people. And I don't know that there's been enough investment in this process to make sure that this is enduring and that it is a legacy that we can really, you know, put a light to and say this is, you know, this is a good job. Because at the moment it's all ad hoc, and it really seems to me that it's about convenience and extraction of the resource.
Thank you.
And getting consent to do so.
Just want to turn to Julia for a moment. One of the things that Marge mentioned was the disconnection from country. And with all of these discussions around treaty and native title and traditional settlement, it leaves the considerable stolen generations community in a particularly difficult place. Are you able to comment on that?
Yeah, I can comment from a personal and perspective maybe, and
Do you mind sharing that with the commissioners?
of course, it's an honour to share. The question is where to begin, and I think if I follow my mum's story, there is always so much work to do for her own well-being. Or I'll get emotional. For the work of her kids, myself and my sister, and the grandkids to find belonging. And similarly to what other people have talked about, the process of finding family and being off country presents a lot of barriers. Not just being off country locally, but being off country at a statewide level. And I think for our story, for my family's story, our family was always, when my family finally reconnected, once, you know, laws and policies changed regarding adoption acts in Victoria, and my mum's birth mother sought her out, the family was so open with their belonging and their identity, but it was just a usual way of knowing, and the family actually couldn't communicate very clearly to my mum what their belonging meant, and that it was a lived experience that happens when you are near people, and culture and community knowledge and connections are learned and discovered by being close to people. And so my mum has always worked so hard up until her birth mother passed away and the old uncles and aunties have passed away, to try and find connection with the family. But the family didn't understand her experience. It didn't understand why she was always her wanting to know, because it was such a everyday occurrence for them, but so unusual for her. So I guess the experience really is of isolation, as a stolen gens person, and often, people that I have talked about and about people that I have talked to about this also say, well, if you can't find your way back to country, come and connect in with our mob. But it's a very different experience, and especially now as families and policies and ways of knowing Aboriginal people are coming smaller and smaller, you have to be able to identify family connection and groups. And the way that policies and legislation work these days, it's not in line with the lived experience of stolen gens. It's the burden of proof again to prove who you are. And so I think there's a real reckoning there of how the state deals with families who are not just individual families. I mean, not just individuals who are stolen gen, but families now who claim this identity because there's nothing else left for folks to claim. And you can have a deep connection on paper, like my family has a long paper trail in Sydney of back to a ancestral belonging, but it's not a lived experience for my family because we've been here. And so there's this, like I was noticing today, just listening to Uncle and Aunt, the stories here are of lived experience. It doesn't matter how much work you do, unless you've lived these experiences and these stories, it's a lot of work to catch up and to try and make sense of the history and identities. And the young ones, like our little kids, want to acknowledge and identify who we are. They're staunch and proud, as toddlers. And I think we owe that to them to find a way in, for them to find their way in. Like we're constantly, we've talked about it a number of times now in this panel. But, when I've worked a lot with Peter Reid up at ANU, doing oral histories and working in Sydney. And in one of his papers, he's written that dispossession is a legitimate experience of being an Aboriginal person. And I think we often are forced to focus on, survival and ongoing connection to culture. But the reality is that, yes, families have been dispossessed, and that doesn't occur outside of these processes or outside of policy making or law.
Thank you. Karen, you've done some work, particularly in the western suburbs, I think, on culture and identity and the impacts of removal. Can you share any of that with the commissioners?
I guess importantly, it's the same sort of story as Julia was talking about, that people who are marginalised in their own community and they're off country find it really difficult to understand a connection, to actually feel like they belong and to have self-esteem in their own identities. So a lot of my work in the western suburbs of Melbourne has been enabling people to connect to country in all of its ways of being, for them to see country in their own backyards, even though it's not their country, and to undertake cultural practice so that they then can undertake daily acts of repair to see country and know country, and feel like they belong. And once you feel like you belong, you have more of a voice, I think, and having a voice is really important for Aboriginal people who have been erased and marginalised, and are not seen in policy and practice in the ways that they're treated. A number of people in the west of Melbourne have had their children taken away from them, or they've been taken away. They've been taken out of schools. They've been abused in all sorts of ways. And I think the importance of relationality and how people understand each other and a community and a collective is a really important space. And it's really important for people who think they're helping communities, but they're not, to understand what it means to be relational. And when you're off country, it's really, really important. And policy doesn't see that. Policy doesn't see the importance of blackfellas and how we relate to each other and how we relate to country. And that needs to shift in order to give space for all community in all sorts of spaces.
Are you in a position to talk about what sort of shift is necessary, you think?
I think it's the shift of White Stream Australia understanding how much they have terrorised Aboriginal people and understanding that they have enacted genocide on Aboriginal people, and that justice in any form, whether it's land or whatever, if justice if land or other means of connecting aren't given with proper justice and understanding Black people's experiences, Black participation and Black decision making, then it's just more of a colonial violence on those people. And I think that's important around how to shift. The hard part is to do that shifting, but it's not for blackfellas to make White Stream shift. They have to do it themselves. And I think part of the work that the Yoorrook Commission is doing in telling the truth can shift some of that. But it needs to be a lot more work from White Stream Australia to do that shifting. It's not for blackfellas to do that all the time. Yeah.
I might ask you now if you can just talk for a moment about the Aboriginal History Archives at Melbourne University, documenting political struggle. Are you able to do that?
Briefly, yeah. And it's Victoria University, not University of Melbourne.
That's what I thought.
Sandstone place that we go.
I knew it was wrong as I was saying it because I've been there.
That's right. You have. Yeah. So I'm really proud that Victoria University houses Gary Foley and Dr. Bruce McGuinness's Aboriginal History Archive, which documents the Black Power movement of what I term as Aboriginal Fitzroy. Aboriginal Fitzroy was where I came to know community. You know, I was not part of community, but when I arrived in Aboriginal Fitzroy, I knew community. And the work that happened in Aboriginal Fitzroy is just phenomenal in its impact on those families and communities. The self-determining, community-led ways of empowering Aboriginal community, empowering parkies, empowering people who are lost, people who came to find community, has had a really long-lasting impact on all of those people who are involved in that space. So the Aboriginal History Archive holds thousands and thousands and thousands of documents which are being digitised to share openly, to change curriculum in high schools or in university teaching, but also to do extra projects with community to help heal. So one of the recent ones was around the closure of the Northlands Secondary College when Jeff Kennett was Premier. And being able to bring that group of young secondary school students together again to talk about their experience in that space actually helped heal a lot of those people, helped them talk about their trauma of what happened and how they were discriminated against, how they were seen as, Black people who had no future, no promise. But their work was absolutely phenomenal in keeping that school going and going to the Equal Opportunity Commission and putting a case into that space. So it's those sort of stories that are in the Aboriginal History Archive that I think are also great for truth-telling and for shifting the ways mainstream Australia thinks about Aboriginal people in more of a strength-based ways rather than that deficit model. It's a really amazing resource, and I'm really proud that we have that.
And there's limited places or mechanisms for keeping those particular stories, isn't there?
Yes. Yeah. Yeah. And ways of sharing it. I think the other thing that we do at Victoria University at Moondani Ballock is bring community in to go through those archives and talk about what's in there and why it's important, and for them to share their knowledge of those sorts of things. So we had an amazing photo day with Marge and a whole set of the Thorpes coming in and talking about all the photos from the Aboriginal Health Service. And so that's really strength-based thing too. I mean, there's so many materials, and that's the other thing around space. Like everybody is now putting their hands up to go, well, I've got more things. We're sort of running out of space to actually hold the physical material. So we're having all those sorts of conversations as well. But yeah, it's a good space.
Thank you. Commissioners, there are a number of areas I had intended to cover with these witnesses. With the schedule that we have for today, it's not going to be possible for me to finish all of those matters, and I propose that we adjourn now for lunch and start at 1:30 with the Surveyor-General. We have materials that have been provided by the witnesses which go to many of the issues that we were going to cover, but the very detailed nature of the evidence that we've been able to receive from these witnesses has meant that we could only take the evidence at a certain pace. I suggest that with the solicitors assisting and your indulgence, we may, and the witnesses' indulgence, we may need to ask them if they might return at some later stage if we can fit them in to finish their evidence. I think that's the best we can do at this stage.
Yeah.
Mm-hmm.
Mm.
On that basis, Commissioner, I would thank the witnesses for their attendance today, and I ask that the hearing be adjourned now for lunch to return at 1:30 for the Surveyor-General. That'll leave a half an hour for lunch. Is that suitable, or would you rather come back a bit later?
Okay, otherwise we're going to run. All right, thank you. And thank you all very much, Graham, Marge, Julia and Karen. You're all wonderful to hear these stories. Great to hear things from the past too, and from different places. Very important for us. Thank you. Thank you. Adjourn until 1:30, was it?
1:30.
Look forward to having you mob back. Still so much to unpack.
Good.
So thank you.
The witness now ready to give evidence is Mr. Craig Sandy, the Surveyor-General for Victoria, and I will be appearing as counsel assisting with respect to this witness. His legal representative is also present and might announce his appearance.
My name is Dan Starr, and I appear with Lachlan Carter for the State of Victoria, whilst the Surveyor-General of Victoria, a public servant of this state, gives his evidence. Thank you, Commissioner Hunter, for your welcome this morning, which I did watch online. And thank you, Chair and Commissioner Lovett, for your comments, which I watched with much interest. I acknowledge the Wurundjeri people of the Kulin Nation, their elders past and present, and thank them for allowing us to have this hearing on their land. I acknowledge that sovereignty over these lands was never ceded. I pay my respect to all First Peoples present here today in this hearing room, or watching online now or at a future point in time. The Surveyor-General is the first of a number of state witnesses to give evidence this week in this significant hearing block on land, sky and waters. The Surveyor-General is present and ready to give his evidence. Thank you.
Thank you, Commissioners. Mr. Sandy, could you please tell the commissioners your full name.
My name is Craig Leslie Sandy, licensed surveyor.
And you hold the position of Surveyor-General of Victoria.
Yes, I do.
And I ask whether the evidence you're about to give to this Commission of Inquiry will be the truth to the best of your knowledge.
Yes, it will be.
And you have prepared a statement in advance of giving evidence to the Commission?
Yes, I have, Tony.
And to your knowledge, the contents of that statement are true and correct?
Yes, they are.
Now, I understand, Surveyor, that you have an opening statement which you'd like to make to the Commission.
Yes, I do.
Would you like to do that now, please?
Good afternoon, Chair and Commissioners. Thank you for the invitation to provide evidence to the Yoorrook Justice Commission in this hearing block 6 on land, sky and water. I would like to acknowledge the traditional owners of the country on which I live and work, the Wurundjeri people, and pay my respects to their elders past and present. Thank you to Commissioner Hunter for your welcome to Wurundjeri country. I also tuned in this morning. And in the spirit of Wominjeka, I come with purpose today. I would also like to acknowledge traditional owners across the entire state. I accept sovereignty was never ceded by First Peoples. I acknowledge all First Peoples in this hearing room today and online for this important truth-telling process and Royal Commission. I am the 26th Surveyor-General of the State of Victoria since 1851, a position I've held since the 7th of August 2017. The Surveyor-General of Victoria is the state's primary authority on land boundaries and has functions and responsibilities that relate to land surveying, land status and electoral boundaries. I provide an important leadership role to land surveying profession, which has approximately 400 practicing licensed surveyors who perform property surveys for the community. I lead an office known as Surveyor-General Victoria, which provide authoritative land surveying, Crown boundary approvals, Crown plan drafting, and geographic place naming services to the government and to the private sector. My role and responsibilities as the Surveyor-General are more fully explained in my written statement dated the 12th of February 2024. In preparing my statement for the Commission and for my appearance to give oral evidence today, I have reflected on the historical role of the Surveyor-General in this state, its legacy and my current work. There have been 4 Surveyors-General for New South Wales prior to the declaration of Victoria as a colony that operated in the area we know as Victoria prior to 1851. The position of Surveyor-General has historical significance and has played a major role in land settlement and land administration within the state. I've reflected on the work of my predecessors in title. My written statement to the Commission includes various acknowledgements, and in summary, these include: I acknowledge that Surveyors-General, both past and present, played a role in the dispossession of First Peoples from their land. I acknowledge that under the direction of the governors and governments, the role of Surveyors-General has accepted the premise of terra nullius. The survey and legal instruments produced from this work were one of the important steps which ultimately resulted in the dispossession and removal of First Peoples from their lands in this state. The land systems established in New South Wales initially and subsequently in Victoria did not recognise the occupation and possession of First Peoples. I accept and deeply regret that the presence on country of Surveyors-General or surveyors under direction has caused First Peoples community significant trauma and diminished their ability to care for country, practice culture, and exercise their rights. I acknowledge that this contributed significantly to a loss of culture and language and impacted the physical, spiritual, and economic well-being of First People. In addition to these and other acknowledgements in my written statement, I have continued to reflect on the historical events, laws, and practices that led to the dispossession of First People from their lands through the settlement and alienation of what is presently referred to as Crown land. I have also watched, listened, and read parts of the evidence given to the Commission, including the lived experience evidence from First Peoples in this hearing block. I recognise and respect the strength and resilience of First Peoples in talking about their lived experiences of injustices, including injustices with respect to land. The evidence of my work to prepare to be a witness to this Commission has reinforced my understanding of the dispossession and removal of First Peoples from their land and the seriously adverse impacts this has had and continues to have on the physical, spiritual, and economic well-being of First Peoples in this state. With all this in mind, as the current Surveyor-General of Victoria, I take this opportunity to formally and sincerely apologise for the role that Surveyor-Generals past and present and surveyors working under our direction have had in the process of dispossession of land from First Peoples of the area now known as Victoria. In making this apology, I accept the actions performed by Surveyors-General did not understand the First Peoples' complex land systems that were in fact already in place. I also understand that Surveyors-General and surveyors employed by them were possibly the first Europeans seen by First Peoples. The work of these early surveyors began a cycle resulting in the removal of First Peoples from their lands. The impacts of that dispossession are still being felt by the First Peoples today in many profound ways, as I have acknowledged in my opening statement. The work of surveyors has been a part of a broader systemic process that enabled land injustice to occur and continue to occur. As the current Surveyor-General of Victoria, that is why I have taken the step I have today to publicly and genuinely apologise for the role of surveyors in the process of land dispossession of First People in Victoria. Thank you for allowing me to say these opening comments. I'm now here to answer questions that hopefully assist the Commission's inquiry.
Thank you. Would you prefer to be called Mr. Sandy or Surveyor-General? Do you have a preference?
No, I'm happy to be.
Well, I'll use the formal appellation and call you Surveyor-General.
Thank you.
Firstly, I just want to have some discussion about your experience and role. You're trained as a surveyor through an undergraduate degree.
Yes.
In applied science, specialising in surveying, majoring in surveying.
Yes.
And you've worked in both the private sector and in government in the role of a surveyor.
Yes, I have.
And you worked in the Northern Territory for 4 years.
Yeah, just under 4 years.
And I understand from your statement that you had some exposure in the Northern Territory to issues involving First Peoples.
Yes, I was involved with determining the extent of rights in relation to the landmark Timber Creek case. As the Surveyor-General for the Northern Territory, my role was to locate the physical assets of the various utilities to ensure that when it went to court, they understood the extent of the area that could be claimed.
You also had some role with respect to the Blue Mud Bay sea claims matter?
Yeah, I didn't have involvement directly with the Blue Mud Bay case. However, I did have involvement with other determinations after the Blue Mud Bay in relation to the Canby land claim. The Northern Territory government created an agreement with the First Peoples, being the Larrakia people, to allow recreational fishers access to the intertidal zone. And so my role was to determine the intertidal zone.
Now, you've been in this role as Surveyor-General since 2017?
Correct.
That's correct. And that role involves a range of tasks, some of them not all of them directly related to each other. Is that fair to say?
Yes, that's a fair statement. So
we'll come to what each of those roles is in some more detail later, but you are you have a role with respect to the geographical place names board.
Yes, so my role is as the Registrar of Geographic Names.
And you have a role with respect to as the Registrar of the Surveyors Registration Board?
Yes, so I'm the chair of the Surveyors Registration Board.
And then you have other roles which more discreetly fit within the Surveyor-General's office. Is that correct?
Yes, that would be correct.
You're not a historian.
No, I'm not.
But it's fair to say that in preparation for the evidence that you're giving here today, you've had some research done, or you've undertaken some research yourself to understand the historical issues pertaining to the Surveyor-General in Victoria?
So as a surveyor, we need to understand history generally, and particularly in relation to land matters. But yes, for preparation, I've done some additional reading.
And on top of that, I might not have the year correct, but you've undertaken you took up an offer made to government officers to attend short courses at Melbourne, University of Melbourne. That's correct?
Yes, that's correct.
But in 2023?
Yes, it was.
And the two subjects that you undertook and were micro-credentialed for is Indigenous and other sovereignties and understanding treaty.
Yes.
And how did you find those courses?
I found them of interest. I found them intellectually stimulating, and I particularly enjoyed the interaction with many of the other participants who came from various places that I've lived and worked throughout my career.
Places outside of Victoria?
Yes.
And were they senior management public service employees, or were they from a range of fields?
I can't really say because I didn't really ask some of them. We interacted on the material that was in front of us. We didn't necessarily ask each other our various roles.
Were there other members of the Victorian government there that you knew?
There were. I didn't know them all, but there were some that I did know.
And so was just exploring this for one more question, was the offer made to government officers to undertake courses for these specific courses or courses related to Indigenous sovereignties or treaty matters? or was it a more generalised offer?
So my understanding is that Melbourne Uni offered these particular courses that related to sovereignty and treaty, and the Victorian government offered them to us in part or in full. And I believe there were 4, of which I've done 2 so far.
Did you find those courses helpful in gaining a deeper appreciation of the subject matter?
Absolutely. That the material was excellent. The lecturers were excellent. In fact, I believe one of the lecturers appeared in this Block 6 hearing the other day, Professor Langton. So yeah, I found it interesting, stimulating, and beneficial to this and my other work.
How long did each of those courses go for?
They were about 10 weeks each.
And is it something that you think government officers generally would benefit from?
Those involved in land transactions or that may be involved in treaty discussions or treaty processes, absolutely.
Now, I just want to move on to some historical issues. You are here representing the Office of the Surveyor-General.
Yes.
That office has a history which is really older than the first settlements in what is now known as Victoria. It was one of the first offices to be created in the new colony of New South Wales. Would you agree with that?
As I understand it, yes.
Prior to the establishment of Victoria as a separate colony from New South Wales, the Surveyor-General for the initial area covered by New South Wales was the surveyor for this area now known as Victoria. That's correct?
Yes.
And you know that in 1836, the New South Wales Surveyor-General was Major Thomas Mitchell.
Yes, I do.
Who later became Sir Thomas Mitchell and was the first Surveyor-General to travel to Victoria, the territory now known as Victoria. Is that correct?
I believe so.
At paragraph 6 of your statement, if you just want to have a look at it, you've got it in front of you.
Okay.
Now, in that statement, and indeed in your opening comments, you've acknowledged the role of Surveyors-General, both past and present, in the dispossession of Aboriginal people from their land. When you acknowledge the role of past Surveyors-General, are you referring to all Surveyors-General of the British colonies in New South Wales, including Major Mitchell, or are you referring to only those that have come into existence since the creation of the colony of New South Wales, or the colony of Victoria?
Predominantly, I would say that I'm acknowledging on behalf of those that were appointed for Victoria. However, I do know that what we know as Victoria now was part of New South Wales previously. And there is some link between our offices. That the Office of Surveyor-General New South Wales created what was known as the Port Phillip District Office, which Robert Hoddle was appointed as Chief Surveyor, and he became Victoria's first Surveyor-General. So there are some links between the offices.
Yes. So I don't, just to be clear, I don't propose to ask you about whether your office or the state of Victoria is now responsible for the actions of Major Mitchell. Okay. I'm not going to ask you about that. Well, but I do want to take you to a few historical matters involving him. You're familiar enough with the story of Major Mitchell to know that he undertook a number of expeditions seeking to map the areas away from the coast and what they referred to as the interior.
Yes, I do.
And you're aware of Expedition 3 conducted by Major Mitchell?
Yes, I am.
And Expedition 3 ran from about the junction of the what's now known as the Murray and the Darling Rivers down towards Swan Hill and then headed south towards Portland. You're aware of that?
Yes, I am.
You're aware that he coined the name Australia Phoenix, meaning happy Southland?
Australia's Felix, yes.
Australia Felix, is that what I said?
Yes, Felix, yep.
And do you accept that when he gave that territory that name publicly, he created a land rush in that part of the colony of New South Wales?
Yeah, I guess, you know, when he described Australia's Felix, he was describing it as this amazing country with lots of water and therefore could sustain crops and various livestock. So I guess that may have led to people wanting to come here.
You can't say whether he knew that or not, but at the time there was a lot of pressure on the New South Wales government to release lands. You're aware of that.
Yes.
You're aware of the Port Phillip Association attempting to enter into a treaty at Port Phillip Bay.
Yes, I'm aware of all of that.
Yes, and so with that knowledge as to the pressure on the New South Wales colony to release land and for the availability of land, the naming and publicisation of parts of the southeastern part of the Australian continent as being a lush and fertile place was always going to have an effect on the demand for land by settlers, wasn't it?
Yeah, I can accept that premise.
Now, you know where the town of Robinvale is?
Yes, I do.
And you're aware that when he was in the area of Robinvale in 1836, Major Mitchell murdered a large number of First People. You're aware of that?
I'm aware of the massacre described as Mount Dispersion, yes.
And so on some accounts, that number was 30 people. You're aware of that?
I've heard various numbers and I've seen various numbers reported in various literature. The New South Wales Government Gazettal doesn't refer to 30, it refers to another number, but it says it was more than the number it gave.
Yes. Now, he also named the place where that ambush and then subsequent massacre occurred by the hill nearby and named that Mount Dispersion. You're aware of that?
Yes.
And that appears to be in celebration or in honour of the dispersion of First Peoples he had murdered and pushed away.
I've not seen the official reason why he gave it that name, but it seems a reasonable explanation.
You're aware that the term dispersal or dispersion was the euphemism used for massacre?
I didn't know that was the case, no.
Mount Dispersion is in New South Wales, you accept that?
Yes.
And Victoria didn't exist at the stage when this happened. It was all the New South Wales colony. I can tell you this, Surveyor. Later in this hearing block, we expect the statement of Mr. Brendan Kennedy to be tendered, and he will give evidence in relation to that statement to the effect that he's a tatty man, being the local people from that area, and he says, there's a place here called Major Mitchell Lagoons at Wackle Junction where Mitchell did more massacring. He massacred people, massacred here at Mount Dispersion, massacred here, massacred there, all along the way. He has monuments built everywhere. These are monuments of conquest. We want to deconstruct all of these monuments of conquest and reinstate our traditional meanings in connection to these cultural places within country, revive the meaning. That's the Bumbangal is the real name. But now it's called Robinvale. I just want to show you the Government Gazette. Can we show the first slide, please? Now, you've seen this in advance.
Yes, I have.
This document is the Government Gazette in relation to the massacre of people at Mount Dispersion by Sir Thomas Mitchell, or Major Mitchell, as he was then known. And so there's no doubt that he did it, that it occurred and he was the perpetrator. You accept that?
Yes, so I've seen the New South Wales Government Gazette.
Yes.
And it describes the events, and I have no reason to not believe that.
Yes. If we could just see the next slide, please. Yes. One more, please. Now the quality of this particular slide in terms of its readability, if we could zoom in on the first column on the top left, we might be able to you've seen this document before, haven't you? It's a clip from the Australian from 1836.
Yep.
And it talks about the expedition of discovery, referring to Major Mitchell's third expedition. You're aware of that?
Yes, I've seen this before.
Yes, and it talks about the massacre of some reported as being as high as 30 people being shot as they ran away and swam across the river to get away from the ambush of Major Mitchell. And this was all on the basis. It reads from that particular article that he was worried because they had been following him. So you've read that article?
I've read that, yes.
Mm. Now, I suggest to you that since that time, Sir Thomas Mitchell, as he's now known, since that massacre, he's had a cockatoo named after him, the Major Mitchell. But I understand that I suggest to you that the name has recently been changed on account of the acceptance of the massacre at Mount Dispersion. The mount continues to be named Mount Dispersion. There is a species of grass called Mitchell grass, which is named after him, which is all throughout the interior of the country. There is a town in southern Queensland on the lands of the Gungri and Mandindangi people named Mitchell in his honour. And he has a string of monuments erected around the country in his honour, including some 30 plus in Victoria. You're aware of all of those facts?
Not all of them. The monuments, I know about them. I've seen some of them. I've visited some of them. Those monuments, however, are not my responsibility.
I don't suggest that they are. And those monuments are put up by local historical societies.
Yep.
But you've been to some of the monuments. What was the purpose for attending on those monuments?
So in my role and in my private life, I travel around the state of Victoria to understand what's there and learn more about its history and various other things that I can find. So as I come across some of these monuments, I don't always know what they are in advance. I just stop in and have a look and I read what they are. So some of the ones I've seen relate to the fact that Major Mitchell passed through here and they're commemorating 100 years since that or some time. Others are where, for instance, at Mount Macedon, near where I live, there's a lookout there named after Mitchell. And so it says that, you know, he named Mount Macedon as he passed through on that journey.
From memory, did any of the monuments that you visited record that he was a mass murderer?
No, none that I recall.
Now, it's not suggested that you or your office is responsible either legally or morally for the actions of Thomas Mitchell in ambushing and massacring possibly 30 people because he felt uncomfortable that he was being followed. But I suggest to you that there are some issues which flow from that fact, which are relevant to you. Firstly, the Surveyor-General's role was an integral part of the British invasion of those territories that took the lands by lethal force in many cases. Do you agree with that?
Yes, we were certainly part of that system. Yep.
And secondly, there is a legacy of feeling held by people, which is apparent in the statement of Brendan Kennedy towards the name, and I suggest to you the office of Surveyor-General by reason of what has occurred in the past. Do you accept that?
Yes, I've had other people express those feelings to me also.
So the first people, you don't have any issue with the expression of some lack of regard, if I can put it that mildly, for the Surveyor-General by people such as Brendan Kennedy?
I've never met Brendan, so you know, I can't express comments around what his feelings might be. However, others have expressed similar thoughts.
Yes, and indeed the people of the Gunditjmara people of the Portland district, whose country was invaded in a massive rush, described as the fastest ever expansion of European settlement, with all the attendant loss of life. You wouldn't have any issue with their feelings of disregard for the Surveyor-General's office, would you?
As I said, I've met people from that group. Some of them express those sorts of feelings. So yeah, I understand that.
Not new to you?
It's not a new concept, no.
No. I just want to draw your attention to this book, The Limits of Location. I understand that it's not a book that you're familiar with.
I've not read that one, no.
No. I want to just have a little bit of a discussion with you about the role of the Surveyor-General beyond the massacres. In that book, the first chapter looks at the roles of Surveyors-General in shaping their colony of Australia. And I'll tell you that the authors of the first chapter observe that the Surveyor-General had the role of overlaying the land with a British system of lines and grids and names when the land already had all of those things. When the land already had its own names and maps of stories and territory and connection to land and language already existed and were recorded in art and in story and in oral histories. You haven't read that chapter, but that explanation of the cultural impact of the Surveyor-General's work, do you have any comment to make about that?
I'm not denying what that chapter describes, because I believe it to be true. However, as Surveyors-General, and I know from reading about past Surveyors-General that many of them also sought to capture some of that existing language, and therefore, certainly here in Victoria, we know that many of our towns and parishes have names that are derived or are actually First Peoples language because they sought to capture some of that.
The overwhelming effect was that in applying the British surveying system of lines and grids and names, there was the effect of scorching the landscape of the culture and law that already existed.
Yes, so that's the principle of terra nullius, and I've acknowledged that Surveyor-General's past, whether it was a disregard or ignoring, predominantly did their work based on that principle.
And so I'm not suggesting to you that they exercised a a legal principle. What I'm suggesting to you is that their role in bringing to the landscape a British system had the effect of pushing the existing system away.
Yes, I agree with that.
And I suggest to you that whilst we've been discussing it in terms of the historical sense, would you accept that the process of negatively affecting culture and law, which is embedded in the landscape in this country, that process is continued every time a new suburb is mapped out on the city fringe?
Yes, so I said in my statement that despite the decision in favour of Mabo in 1992, many of our land systems have not altered, and therefore that I agree with your statement. Can I just say, however, that the Surveyor-General is governed by the laws of the state of Victoria. So while I might agree with that statement, I still have to follow the existing laws.
Does that mean that the rights and interests of the existing rights and interests of the First Peoples don't get recorded?
That they get recorded according to the legislation that we have at the moment.
Is it the case that the way in which the system is established doesn't permit you to record the existing stories or connections that the traditional owners have to those lands?
Probably not in the way that First Peoples would like that to occur.
Well, are you saying that it is possible in some sense?
If we're talking about mapping, we have ways to map various rights and interests.
And
have we mapped the rights and interests of the First Peoples prior to colonisation? The answer is no.
Post-colonisation, Surveyor?
Or post
in the present day?
Only to the extent we've been requested.
If you were asked to map those interests today across the state of Victoria, those interests which the witnesses who have appeared before this commission say are continuing and vibrant interests, replete with culture and stories and art, is that something that you could do if you were requested by the government to do that?
Yes, we could.
Do you have the ability to do it technologically?
Yes, we do.
Do you have the resources to do it?
Well, that's another discussion.
Are you saying no?
So if we were requested to do it, a request would come to us. We would hope that there would be some resourcing provided to us to enable us to do that. If we had to do that under existing resources, then it would be a matter of we would have to determine our priorities and prioritise.
You have the capacity within your office of the Surveyor-General's office to undertake that work at present?
At present, I would say we don't. Our focus is on other government initiatives at the moment, such as the Big Build and various other initiatives, some of which are related to state parks and forests.
I just follow that point of the Big Build for a moment and then come back. You accept that the Big Build is likely to impact on the very rights and interests that we're talking about?
Yes, I am.
So in your office at present, what's the staffing number?
Approximately 85.
And how many of those staff are First Peoples, Victorian First Peoples?
that have identified as First Peoples, the answer is 1.
And do you think that that's a satisfactory level of employment in an office so integral to the management of the lands for this state?
No, I do not.
And what steps have you taken to increase the staff numbers?
When I started, there were no First Peoples employed in the office. My first approach was to look to employing First Peoples in a space where that they could have the most impact. So the first role that we put out for First Peoples was in geographic naming, and we've employed people in that area, and I'd love to have some more. In terms of land surveyors have got to go through a training process, so a degree and then post-degree training. And so because we can't just go and find First Peoples with that training, we started by offering scholarships to try and attract First Peoples to surveying roles.
To scholarships in terms of funding tertiary education?
Correct.
And how successful were you?
So the scholarships were specifically for women and First Peoples, and I believe of the 7 scholarship holders, we've had 2 that have identified as First Peoples so far.
Any of them completed their study?
My understanding is that at least one of those have, and unfortunately we weren't able to attract them. They took a role in the private sector.
Now, before I just move on, I just might give the commissioners an opportunity to ask any questions, Surveyor-General, in relation to those matters. No.
I just noticed in your statement, Surveyor-General, that you talk about the custodianship of First Peoples rather than ownership, and custodianship sort of means responsibility for rather than owning. Can you tell me why you've used that term rather than owners?
Yeah, so there was a number of reasons I used that term. So in some of my readings of First Peoples, they actually refer to custodianship of the land. And I'm trying to think of who it was. I can't recall. It may have been in Pat Ockwell's book. I would be going into personal opinions, which I won't, but really we're all custodians in some form because we all have we all live for a period of time and then we pass on to others. So in many respects, we're all custodians.
My land title doesn't call me a custodian.
Calls you a landowner.
Yep.
Yeah, I understand your question, and I know that in the Torrens title it talks about ownership.
You said you had one Aboriginal staff member or someone who identifies as Aboriginal or Torres Strait Islander. What level in the organisation are they?
In terms of Victorian government, I think it's VPS 4 at this moment in time.
And how does that VPS 4 align with other people who are out of the, was it 80? How many did you have? That again? 80?
85.
85 staff. So what are most of the majority of people VPS in that area?
So in the place or geographic namings, there's only 4 staff. The manager of that area is a VPS 6 and reports directly to me. The other staff in that area, we have another VPS 4 and then we have a VPS 3.
But in parallel to the 85, where does it sit? The 4.
We have quite a number of VPS 4 staff. because our surveying roles, that there's a level of training and then postgraduate training. Licensed surveyors achieve VPS 5, and then those that are above that are senior licensed surveyors.
And you made reference before to resourcing, ability to be able to map country from a traditional owner perspective. Have you put any proposals forward for government to consider in investing in such work?
At this stage, no, I haven't.
Okay.
I might continue on. Prior to this Yoorrook process.
Sorry, can I just, is that all right?
Sorry, Commissioner.
No, you're right. Firstly, I'd like to add that there is also a shire of Mitchell within Victoria, not far from where I live, that was only established in 1994. So I just wanted to, quite recently. So you've made your opening comments in your apology about what's happened, and I acknowledge that the Surveyor-General, both past and present, played a role in dispossession of First Peoples land from their land. So in making that apology, what are you going to do differently moving forward?
It's not what I'm going to do differently, it's what we're already doing. So before this commission commenced, I was already looking at what we could do better. In the former Department of Environment, Land, Water and Planning, I worked closely with the First People Self-Determination Group within there, and we had various discussions, mostly around geographic naming, but we also talked to them about engaging in relation to the work that we do around the Traditional Owner Settlement Act. And so there's things that we've already been doing before I had to start researching for the Yoorrook Justice Commission. And when I say we've started, it's a journey and we're only just beginning.
Thank you. Plenty of people come before us with apologies, and I think it's not just the apology, it's what it comes with. So I just want to note that. So thank you.
Thank you, Commissioner Hunter.
I just ask Mr. McAvoy, in paragraph 60, Mr. Sandy, you refer to the 2021 government review, the Land Act, and seemingly it has some effect on the matters that we're discussing, that is recognition of Indigenous interests in land. Can you tell us where that's at?
Specifically, no. So I've not been involved in some of the reviews that have occurred at this moment. I know that Land Use Victoria has been involved in those, but I can't give you an update. I don't have that information.
Well, you've referred to it in paragraph 60 for some purpose, obviously.
So I agreed with the sentiments of the statement that I included, and where I can assist, I will. At this point, I've not been asked to assist.
Are you aware that the review hasn't been made public or completed?
I'm not currently aware of where it's at.
Now, I just want to take you to your role as chair of the Surveyors Registration Board. Just in brief form, could you explain to the commissioners what that board does?
So the primary role of the Surveyors Registration Board is to license or register licensed surveyors to perform what we call cadastral surveys, which is property boundary surveys, and to train people to become licensed surveyors,
and to ensure that a particular standard is kept in terms of the performance of the role of surveyors.
So the board keeps the standard, so has the ability to discipline licensed surveyors. In terms of setting the standards for surveying, that falls to my role as Surveyor-General.
Okay, and as the chair, you have ultimate responsibility for that board.
Yes, I do.
On the government website for the board, you're aware that there's a document called the Survey Practice Handbook.
Yes, I am.
And on that government website, the Survey Practice Handbook comes with a warning in the following form. Many sections of the handbook are now out of date and should be used with caution.
Yes, that's correct.
You're aware that the website makes that disclaimer?
I do.
Have you looked at part 3 of the handbook?
Yes, I have.
And that part 3 of the handbook is titled Surveyor's Practice Handbook Part 3 Land Surveying Law and Administration. And section 3 of that part is titled Land Settlement and the Role of the Surveyor. You're aware of that?
I am.
And that section is noted as having been compiled by a person named A.C. Brown and is noted as being the 1994 update.
Yes, I'm aware of that.
And the other sections of that handbook have all been updated to around about the same time, 1994. Is that right?
Correct.
And I suggest to you, and I don't suggest you'll know this off the top of your head, but a search of that particular section of the handbook in relation to land settlement and the role of the surveyor discloses that First Peoples are only mentioned 3 times in that whole section. First, with respect to incidents with natives at the 1803 Sorrento attempted settlement. Secondly, in relation to the Port Phillip Association plan to establish a right to possession by purchasing land from the natives. So that's the Batman Treaty reference. And third, by quoting the Burke Proclamation of 1835. The document does not mention the 1992 Mabo No. 2 decision.
Suggests it's very much out of date.
You've been in this position since 2017.
Yes.
Is there any process by which you systematically review the documents of the Surveyors Registration Board to ensure that they're updated?
Yes, we do. That particular document, I was surprised to find it on the Surveyors Registration Board website, to be honest. So I'm taking steps to move it back to its rightful place, which is on the website of the Surveyor-General of Victoria. And in addition, have commenced a process to update that document and to ensure that it reflects the true history of Victoria.
The purpose of a survey practice handbook is to guide surveyors in the carrying out of their work, isn't it?
Yes, it is.
It's to ensure that they have the right information to allow them to do their job properly.
So the reason the document is up there is it's been put there for surveyors to use as a historical reference. But when it's severely out of date, then there's questionable value in a document that's so far out of date, which is why I've taken steps to update it.
Well, I appreciate that you've taken steps now to update it, now that it's been brought to your attention that it's
these actions were taken 3 years ago.
The update process was commenced 3 years ago.
Yep.
And so when will that update be completed?
That's a good question. I'm hoping that we might have it completed in the next 2 years.
It's going to take 5 years to update that document.
There's a significant amount of work to go into updating it. Firstly, there's very little mention of any history prior to 1803 of which we know that First Peoples occupied Victoria for a much longer period prior to that than since 1803. And since then, as you mentioned, that the 1992 Mabo case is not in there, and the ramifications of that, which means there's no mention of traditional owner settlement acts. So it requires a significant upgrade.
The consequence of that document having been available to surveyors for the past 30 years is that 33 decades worth of surveyors have looked to that document to provide the underpinning for their work, and they are encouraged, it would seem, to do it without reference to the actual law of the land. Do you accept that?
I understand where you're going with that question. So while it's a reference material, the training of surveyors it follows a different course to just looking at that document. That's really a reference material. Also on the board's website, there are documents that talk about a professional training agreement and what is required to complete a professional training agreement. And that provides step-by-step guideline to surveyors in the legislation and what we expect of a licensed surveyor before we allow them to be registered.
You accept that it might be concerning for the commissioners to hear that document's still available on the website, though?
It is concerning, and that's why I'm looking into it, because it was this process that identified that it's located in the wrong location.
You accept that part of the difficulty for a truth-telling commission such as this one in dealing with government agencies is that government agencies are very slow to make any cultural shift. You accept that?
Yes.
And you accept that the terms of reference request that this commission of inquiry make recommendations as to how the Victorian government might be better at its job and deliver on treaties and make amends for its past injustices. You accept that?
Yeah, I'm looking forward to those recommendations.
And one of the difficulties I suggest to you that the First Peoples of Victoria have, and this commission will have by extension, is that these types of documents continue to exist within the Victorian bureaucracy, and they get turned up in the course of these processes, and the government officer in question turns up and says, "I'm really sorry, it shouldn't be there," but they're there. You accept that that's a problem?
Yes, I do.
How does the government? How does your agency deal with that to ensure that there aren't these documents, that there is the cultural shift within your agency to ensure that not only the spirit but the actual terms of any changes that are recommended by this commission are embedded and cannot be deviated from?
So I'll only answer the one that's been recognised. I will ensure that the document is removed. We will progress the update to it before we put it back in its rightful place, because these are important documents, and the fact that it's out of date means that we haven't put enough focus onto some of these things.
Well, that wasn't the question I asked. I asked is how does this commission ensure that the cultural change in government agencies that is needed is actually performed? What do you say as to how your agency, we'll narrow it down, as to how your agency can go about becoming the type of agency which proactively and properly participates in the change that's necessary to see the treaty process successfully undertaken?
So the way that we do anything is that we identify it, we create an accountability process, and we operate to that, and we report that to our superiors, which are, through to the secretary or the minister.
And if there's no performance against those accountabilities, what's the consequence?
I try not to put myself in that position. However, if there's no accountability and you haven't performed, then you'll either be removed from office or that's probably the ultimate.
Can I just ask, how can we be assured that there's no other documents like this within your department that don't reflect a true history of our people and then don't take into account what it means? Because we're talking about land.
I will only talk about the areas that I have focus in. I won't talk broadly about the department.
But in what you oversee,
my area,
how can you assure me that you will look at all these documents and then these documents will be updated and that there's nothing floating around like Mr. McAvoy has pointed out? How can we be assured of that?
So our website where we make many of these documents available is reviewed frequently. The land.vic.gov.au website, which I'm on.
You can say that that's reviewed, but Mr. McAvoy's just showing us a document that hasn't been reviewed since 1994.
I was going to get to that one. So that one sits on the Surveyors Registration Board website, which is a separate website. And we are in the process of updating that website and looking into all the documents that are on there. And this process has identified one that probably shouldn't be there, which we acknowledge.
There's no there's no replacement document.
Not at this stage.
Not ready to be uploaded to the system.
Not at this stage.
Sorry, Commissioner.
In the review process that you've undertaken 3 years ago, was it 3 years you started it? What type of engagement, not consultation, engagement, have you been doing with traditional owners to involve them through this process so far?
We didn't get to that stage.
In 3 years?
In 3 years.
You think that's an issue?
Yes.
Should there be immediately something on the website to indicate that this is out of date and that you are undertaking a review and changing it? Something can be done straight away?
Well, there already is an acknowledgement that it's out of date.
You would accept, though, that the acknowledgement is not that it's out of date, particularly with respect to First Peoples issues.
No, it doesn't. It doesn't go that specifically.
Now, the question I asked you a few moments ago about ensuring that the cultural change happens within the Surveyor-General's office, and by extension how it might be done in other agencies. You answered that there must be accountabilities and hopefully people are held to account for their performance or non-performance. You would accept that it's not inappropriate for executives of the government to have in their contracts of employment conditions requiring performance of the self-determination principles or performance in relation to the treaty outcomes that the government might enter into.
I don't think it's specifically in my contract, but it's certainly in the performance documents that I work towards.
So if you fail to perform in respect of the self-determination principles, is that a matter in respect of which you could be subjected to some disciplinary action?
Yes.
Are you aware of any government officer in the Victorian government having been subject to disciplinary action for non-performance of against the self-determination principles?
Not to my knowledge.
You came to the Surveyor-General's position in 2017, that's correct?
Correct.
By that time, the First Peoples Self-Determination policy framework had already been established in Victoria and was underway. I'm going to put a proposition to you that self-determination for First Peoples requires the government and those who work with the government to have a sound understanding of the history and law in relation to First Peoples. You'd accept that?
Can you say that again, please?
That those who work with government, self-determination, the performance of, I'll withdraw that. You would agree that to ensure that self-determination is afforded First Peoples, government and those who work with government need to have a good understanding of the history and law relating to First Peoples.
Yes.
And you clearly have a personal interest in treaty and Indigenous sovereignties because you undertook the courses at the University of Melbourne. How well informed would you say the Surveyor-General's office is in relation to those matters?
Hard to quantify. I mean, we're talking about a group of 85 people. So I'll talk for myself. I've spent a significant amount of time ensuring that I learn about the history that's required, understanding the treaty process, and where we as a group, Surveyor-General Victoria, may be involved in the process. It's something that we as a group speak about from time to time because there are matters that we deal with. For instance, we have staff learning sessions, if you like, where we talk about some of the projects. So some of our staff would mention the work that they're doing specifically in relation to Traditional Owner Settlement Act. So we do have those discussions, but can I quantify the knowledge of the staff? No.
The fact that the practice handbook has stayed on the website for who knows how long indicates that there may be some deficiencies in some parts of the organisation in terms of their knowledge and understanding of the law and culture of First Peoples.
Yeah, I wouldn't necessarily agree with that. So we all have a responsibility to do our cultural safety training, which we encourage our staff to do. And where it's considered mandatory, they do that. Our surveyors are required to understand the application of the law in relation to the surveys they perform, which include surveys that involve actions under the Aboriginal Heritage Act as well as the Traditional Owner Settlement Act and others. So from a surveying perspective, my surveyors would have a good understanding. However, in terms of First Peoples cultures and laws, that there would be a knowledge of learning that they would still need to do.
Thank you. Now, your office has produced a strategic plan for the years 2020 to 2025.
Yes, we have.
And that strategic plan, I suggest to you at page 6, shows that the Crown land was approximately 35% of the land in Victoria in 2020. And by information provided to you but from the Valuer-General's office was valued at approximately 300 billion. You're still aware of that figure from your
So we are aware of that figure. It's referenced as a government source, but it doesn't specifically refer to the Valuer-General. So we had someone produce that document for us, and while we checked that there was a government source for it, and we did go and have a look at it, the Valuer-General's valuations we would take as the value that it actually is.
And so the math would tell us that with 35% of the land as Crown land, the remaining 65 is non-Crown land and therefore in private hands. And in that strategic plan, you've identified that it's freehold, but it might also be leasehold or other forms of private ownership.
It's private ownership, yes.
And the figure that's in the document is 2.3 trillion, but you don't say that that's necessarily correct.
No, the 2.3 trillion was directly from the Valuer-General's, and we refer to the Valuer-General's reference to that one.
There are a number of questions that I might have had from you, but I'm aware of the time, and I just might ask you, on page 26 of that document, there's some information in relation to airborne gravity surveys.
Yes.
That's a new area for the Surveyor-General's office, is it, or relatively new?
Well, it's a project that's now been going since about 2019, but it was a new survey when it commenced. Yeah, it's the first of its kind in Victoria, certainly. maybe even it's first of its kind in Australia.
So the purpose of this airborne gravity survey is to measure the airspace in a sense that it might be commodified in the way that land is commodified. Is that correct?
No, that's not correct. You're applying the principles in a different way to what we are. The purpose of that survey is to understand gravity, the value of gravity, and how it applies to us determining the height. Predominantly, most heights are measured above sea level, which we refer to as the Australian height datum. However, that has some historic biases and some errors. And so by utilising this technique, we can actually produce a better heighting system.
Yes. Now, I just wanted to take you, I think I might take you back to page 13 of that plan, which shows that the Surveyor-General is responsible for leading in 5 areas, including diversity and capacity, and that a Surveyor-General Victoria team leads on geographic place names, including Aboriginal place naming. You accept that that's what's on that page?
I do accept that.
And that's still a current organisational chart in terms of the allocation of those duties?
Mostly it is. Some of the groups identified in that particular strategy have changed in their name. However, predominantly it describes our current structure.
So I just want to take you now to page 27 of that document, and it's fair to say that there has been some work that your office has had directly with First Peoples of Victoria in relation to geographic place names?
Yes, there has been.
The system of place naming in Victoria is one where there are local place naming authorities appointed?
That's correct.
And some of those local place naming authorities have included First Peoples organisations?
So where First Peoples are responsible for land, then they can be the naming authority. In most instances, however, the local government are the naming authority, with the exception of some government agencies.
But there have been some cases in which First Peoples have taken up the opportunity to be the local naming authority?
Yes, there are. So any land that has been provided to First Peoples for their occupation, control or responsibility, that they form the naming authority.
And there's a Geographic Place Names Advisory Panel, which is appointed by the Minister?
Yes, there is.
And that's the Minister for Transport and Planning, is it?
It's the Minister for Planning.
Planning. And are there any First Peoples on that panel?
Not currently.
When was the last time there were First People on that panel?
2020, I believe.
2020. And I think that person was Mr. Paul Patton.
I believe there might have been 2, but Mr. Paul Patton was one of those.
When he was replaced, you know,
well, let me stop you if I may. At the time in 2020, when Mr. Patton's term expired, panel members were not replaced.
So there had been no replacement of the panel members, the position that Mr. Patton
not at this moment, no.
Okay. Now, I just have short observations to make, and
hang on. 10 years we're celebrating Indigenous languages, and we don't have anybody from 2020. Nobody represented to be able to help. Enable.
It's not quite that simple. So the panel is put in place to investigate naming matters as they come up. In terms of the decade of Indigenous languages, we take a different approach to that. We don't rely on the panel. So our First Peoples Place Naming Officer is responsible for leading that work. And he's working closely with our department's First Peoples Determination and Reform Group. And we're doing things differently to what we did in 2019 when it was the International Year of Indigenous Language. predominantly in 2019, myself and others in the team, we didn't fully understand the engagement needed with First Peoples. And so our approach was to create a series of initiatives, some of which were First Peoples led and some were not. However, we understand that really it should be First Peoples leading these. And so our approach is to engage with them rather than us creating the initiatives, engage with them and then support them in whatever initiatives they believe they need to take.
So, I mean, it's still a junior role within the department or within your group. But I guess what I'm trying to get at is that there's nobody on that ministerial, was it a ministerial appointed?
So it's ministerial appointed.
Yep. And no Aboriginal voices on there since 2020.
Because none have been appointed since then.
But do you see that as an issue?
It would be an issue if we'd needed to use the panel, but the panel has done its work the last that it was called. And should we need to appoint a new panel, then we would appoint people.
And no panel members exist anymore?
There are 4 panel members that exist.
Right now?
Right now.
But no First Nations?
No First Nations.
You have determined that there's no First Nations voice needed?
No, that's not quite...
I don't understand what you're saying though, because it's sounding vague to me. It's probably why I'm trying to question and understand.
It's sounding a bit vague because we went through a process to try and appoint some more people to the panel, and we weren't able to appoint them, and the government has made a review of those types of panels and is in the process of removing some of those, including the Geographic Place Names Advisory Panel. However, that doesn't prevent the Minister from appointing committees to investigate naming matters.
If I might, Commissioner Lovett, the panel itself is drawn from to populate committees to then do particular tasks.
That's correct.
It's not the case that the panel sits full time. That's correct. And who was the relevant minister at the time? Mr. Patton's term expired.
So I believe it would have been Minister of Planning would have been Minister Wynne at the time.
Now, unless the commissioners have some further questions about that panel and that process, I understand that there's a lot more detail that we could discuss with this witness in relation to that, but I'm also conscious of the time. Surveyor-General, you've, at the request of the Commission, prepared some slide presentations with respect to the Coranderrk and Lake Condah reserves.
Yes, I have.
Those PowerPoint presentations are in the Commissioner's material. Given our time restrictions today, I don't propose to take you through them as I had, but I can indicate that the process of identifying the land dealings that occurred with respect to those particular missions is very insightful in terms of the way in which First Peoples reserve lands are dealt with, and you would agree that in each case, part of the land that was set aside was ultimately granted in part to non-Aboriginal returned servicemen?
In the Lake Condah case, yes.
Not in both cases?
I didn't recall seeing any soldier settlement in the Coranderrk land.
Commissioners, I would encourage you to take some time to review those slides if at a convenient time. I don't propose to take this witness through them now. Those are my questions of this witness, unless the commissioners have any other questions. I propose to sit down.
Quite a lot of material that we haven't got to do because of when we got the material, so it's important that we check the pieces we wish to, and I suggest that relating to Aboriginal, but the Coronavirus one, the other reference, would want to do so.
It may be possible, Chair, to direct some further questions to the Surveyor-General in writing or response if there's anything arises from the material.
Happy to answer any questions in relation to it, either now or after.
Further questions? No, we've got. Okay.
Anything further you'd like to say that you haven't been able to say today?
No, only in closing that I thank the Commission for the invitation to come and talk to you. I reiterate the words of my apology and my opening statements, and I'm looking forward to the recommendations of the Commission, and I'll do anything I need to assist you in your inquiry.
Chair, I understand that that my learned friend Mr. Starr has one matter of clarification he'd like to raise.
This is the Commission. I was going to clarify some matters to do with that panel and the committee, if the committee would want that clarification now, because I'm not sure that it was clear enough what the witness was saying. And if it's a matter which the Commission, in particular Commissioner Lovett, is interested in, I could assist to clarify that with the witness.
I think it's clear now, but thank you. Yep, I understand what you're saying now. Thanks.
Thank you, Commissioner.
I got two minor things, sorry. Data sovereignty. The department's committed to, under the self-determination reform framework, about transferring data and so forth back to traditional owners. What are you doing about that, if anything?
So the first case of that is Budge Bim, and some of the work that we were involved in some of that. I think it's a good model for data sovereignty across Victoria, but that's the start of a journey.
And one other thing was, when was the last time the acts that you were governed by were updated?
So the three main acts that I work under are the Surveying Act, which was 2004.
Yep.
The Geographic Place Names Act, which was 1998, and the Survey Coordination Act, which is 1958.
And when, thanks for that. The question is, though, when were they last updated? The recency of the updates. The last couple of years, have they been updated?
So the Surveying Act was updated on the 1st of March 2023. In terms of the other two, I couldn't tell you the exact dates when they were updated.
And any reference to traditional owners or Aboriginal Victorians in that 2023 update?
No, I
Given
don't.
the government's commitment to self-determination on a pathway to treaty and whatnot?
Yeah, I don't believe so. The updates related to the passing of a Commonwealth legislation.
Like, that could have been an opportunistic time to make some further additions to that act?
We were not given that opportunity.
Thanks.
Nothing arising, Chair. The witness might be excused.
Thank you, Commissioners.
You want to keep going?
Yes, Ms. McLeod is taking the next witnesses, which are the panel of in relation to water. And if they might have a moment just to assemble themselves. Thank you.
Thanks very much.
Thank you.
Surveyor-General, thank you.
Thank you, Chair. I appear for this panel session with Ms. Weinberg. And the panel we have this afternoon is Dr. Katie O'Brien. Sorry, and slightly out of order as I go along the line, Dr. Erin O'Donnell, Will Mooney and Carmen Jobling. And I should ask how you would like to be referred to in this session, would you prefer doctors or first names? Because witnesses have chosen both. So I'm in your hands.
First name for me.
Yes, thanks.
Yes, thank you.
So Chair, I'll first go along the line, and then as this is the first panel session dealing directly with water, we'll commence with an explanation around water and the significance of water. So can I ask each of you, starting with you, Carmen, along the line in reverse order, do you undertake to tell the truth today to this commission to the best of your ability?
Absolutely.
And you will?
Yes, I do.
And you, Katie? And you, Erin?
Yes.
Thank you. Commissioners, this hearing block is focused on land injustice, as we've heard, and the history of dispossession of land, theft and loss of economic benefit. Today's panel is the first time the Commission is considering water and water rights. The panel are aware that we will be calling traditional owners and a panel later in this hearing block, and will hear evidence on country from elders and those with cultural authority to speak for country, and to hear directly from First Peoples about the significance of water. Commissioners, we acknowledge in this process the enduring spiritual, cultural connections to waters of First Peoples and their cultural authorities to speak for water, rivers and river country. Can I invite each of you to introduce yourselves and your work, commencing with you, Carmen.
Oh, first, I'd like to acknowledge that we're meeting on the unceded lands of the Wurundjeri people. Pay our respects to everyone here today and viewing online. My name's Carmen. I'm the Executive Officer of the Murray Lower Darling Rivers Indigenous Nations.
Hi, my name's Will. I work for the Murray Lower Darling Rivers Indigenous Nations as well. Likewise, I'd like to acknowledge traditional owners, particularly everyone viewing online today. I'm a project manager at Mildren and have worked in various roles collaborating with First Nations around water justice in the Southern Murray-Darling Basin.
Thanks, Will. Katie.
Thank you. I'm Dr. Katie O'Brien. I'm with Monash University, and I too would like to pay my respects to the Wurundjeri people. And I've been researching in Indigenous water rights for a number of years, following about a decade working in native title.
My name's Dr. Erin O'Donnell. I'm a settler heritage person speaking to you on the lands of the Wurundjeri Woiwurrung, and I pay my respects to their elders past and present, and I pay my respects to everyone here with us today and joining us online. I've been working in the water space for over 20 years, and more recently in the last 5 or 6 years on Indigenous water injustice. I'm a lecturer at the University of Melbourne, and I'm also a member of the Birrarung Council, although I'm not wearing that hat today.
Thank you. And Katie and Erin, you are two of a number of authors of a document called Caring for Country, Overcoming the Twin Legacies of Terra Nullius and Aqua Nullius, that we'll come to sometime this afternoon. Thank you. Commissioners, water exists in, on, under and above the land. It exists as fresh water and salt, in the soil and in the atmosphere, in cycles of scarcity and abundance. It is vital to the survival of all species, and we acknowledge the thousands of years of knowledge of adaptation of First Peoples and other species in balance with the seasons. Water is also revered in many forms as the expression of spirit or the divine, and recognised in some limited way in this state as living ecological entities attracting legal rights. So can I ask the panel then to start here with the discussion around the recognition of these notions and the discussion of the declaration known as the Echuca Declaration. And if I can start with you, Carmen and Will, what is the Echuca Declaration and how was it created? And perhaps if we could bring it up on the screen.
Commissioners, thanks for the opportunity to discuss this really important piece of work which Mildren led in 2007. So the Echuca Declaration is a foundational and visionary document that directly contends with and confronts the settler state's assertion of control over water and the dispossession of First Nations from control and maintaining responsibilities and obligations relating to water. As the name suggests, the declaration was made in the town of Echuca on the banks of the Murray River in northern Victoria in 2007. A number of traditional owner groups from the southern part of the Murray-Darling Basin came together to discuss, I guess, in the wake of the Millennium Drought. So during the Millennium Drought, when some of the worst impacts of water over-allocation were being felt directly by First Nations.
When were those years, Will?
So the Millennium Drought, well, as the name suggests, so from the early 2000s, it really until about 2010, 2011, when the first rains really came and broke that drought. I suppose that time really exacerbated some of those impacts that many people had been experiencing as a result of the over-allocation of water and the Crown's assertion of control over water. So that the Echuca Declaration contests the Crown's assertion of control and ownership of water. It states that the Crown has illegitimately asserted its control, and it seeks to reimagine rivers and water as a living being, to which First Nations have obligations and responsibilities through law and custom to care for.
I'll just pause you there, sorry, because I don't want to miss the detail. I'll just check if we can get that up on the screen so others can follow.
So it contains a preamble that I suppose spells out the legacy of the colonial settler state imposition of law over First Nations water rights. And then it also lays out a platform to, I guess, address and rectify that situation through a mechanism which the Declaration defines as cultural flows. And cultural flows are water entitlements that are legally and beneficially owned by First Nations of an adequate quality and quantity to improve the conditions of life of First Nations in all aspects.
Sorry, let me pause you there. Can we get a copy of the Echuca Declaration up on the screen, please? Okay, thank you. So sorry, just breaking it down, Will, so we capture the detail of it. You said the preamble sets out some important foundational concepts, including this notion we're familiar with in discussions around land, that sovereignty was never ceded.
That's right. So the preamble...
If we could just zoom into the top half of the page.
I suppose it really describes the situation that the authors could observe at that time, which was a situation whereby the Commonwealth of Australia and the States had asserted I think it uses the terminology of a competing sovereignty over water, and it rejects that assertion by the colonial states. And then it goes on to map out a series of mechanisms whereby that illegitimate assertion could be addressed, I suppose, or overcome to some extent. And then it contains a number of articles that really, in quite a lot of detail, specify what cultural flows are. So it establishes the definition of cultural flows, and then it talks through how cultural flows should be delivered, how volumes and quantities required should be developed. And Mildred, I suppose, to sort of bring this up to a contemporary conversation, we still regularly go back to that document because it is there's a lot of forethought went into its preparation.
So just to frame this, Mildred represents traditional owners from where?
Yep. So Mildred has representative members from the southern part of the Murray-Darling Basin. So, and again, this is probably an artefact of settler state law, but the Murray-Darling Basin is generally broken up into a southern and northern section. So the southern section runs from around about the Lachlan River in New South Wales through Victoria and into South Australia, where the Murray enters the oceans on Nurundjeri country.
And the number of TOs who are involved in Mildred?
I might refer to Carmen to give us a bit an updated kind of summary on membership.
Yeah, so we have about 20 representative members from 20 nations.
Okay.
Each nation can have 2 reps.
And this document, what was the motivation for this document?
I think you could look at this document as an intervention in the water space. 2007, there was a lot happening. Of course, we were in the grip of the Millennium Drought, but it was also the year that the Commonwealth Water Act was brought into law. there was a live national debate around water and around the state of the Murray-Darling Basin and the impact of drought and the impact of water extraction. First Nations, I understand, needed to intervene in that space. There were also discussions about the development of a Murray-Darling Basin plan. So it was the first time that the Commonwealth had actually asserted its authority over water management. So it was a strategic intervention in the public discourse about water, and it was really an assertion of First Nations rights, substantive rights to control, own and manage water on their country.
So you mentioned the term cultural flows and the need to reference cultural flows in this document. What's the difference between environmental flows and cultural flows? Because environmental flows, as I understand, can have a cultural benefit.
That's correct. So I think the context is illuminating here, because at the time when the Echuca Declaration was developed, there was a discussion about the need for environmental flows to address to essentially return water from consumptive use to the Commonwealth environmental water holder, or to a mechanism where it could be managed for environmental outcomes. And I believe that First Nations at the time recognised that that was important, but they also recognised that there was a self-determining right for nations needed to be able to also control how water is managed and used on country. So cultural flows is fundamentally different because it's grounded in the self-determination of nations to use that water as they see fit, and to use that water to improve the conditions of their life, as well as to care for country. And I suppose the Declaration makes it very clear that it is an inherent right. It's an inherent sovereign right of those nations to have that control, and to, I suppose, contest the Crown's assertion of control over all water.
We might just zoom out for the full document again, please. The document, the Declaration, also makes reference to the actions of the federal and state governments. They have not taken proper care of the country and made all of the land and water sick and unhealthy, that many of the plants and animals have died out and will never return, and have failed to properly care for country, and have not allowed us onto our lands and waters, denying us our basic human rights and our sacred places. So do you want to both say something about that and the environmental stewardship or responsibility and rights attached to that of First Nations people for the environment?
I'll make a passing comment and then open it up to others, I think. Yes, I think that's one of the foundational elements of the Declaration, is that recognition that not only has the settler state imposed its ownership and control over water, but it's done a really poor job of caring for waterways and caring for country in that intervening 200 or so years. So, it's asserted control over waterways, and it's managed or mismanaged waterways to the extent that I think it uses the terminology of ecological collapse, and First Nations have been borne some of the worst impacts of that environmental degradation. And so again, that's a critical part of the Declaration and its platform, I suppose, to reassert that right.
Do you want to add anything to that?
No, I think that pretty much covers it, Brian, but perhaps.
Yep. So, Erin and Katie, can I ask you to reflect on the Declaration initially, and then more broadly this concept I want to move to of acknowledging rivers, waterways as having legal personage or recognition under law?
So I think what the Echuca Declaration really spells out is the enduring legacy of aqua nullius, which was the assumption by the settler state that they could assume all authority for the control and care of water. And in doing so, since British invasion, what has occurred is the imposition of settler state sciences and ways of knowing, settler state frameworks for water extraction. The Water Act 1989 constructs water solely as a resource for human domination and exploitation. This sits completely at odds with the Echuca Declaration and what cultural flows mean to Aboriginal people and to the notion of water as a living entity. So what we are now witnessing is over 2 centuries of mismanagement which is driving that ecological collapse, but it stems from the assumption, the theft of the authority to speak for water.
Just to explain the history of this, we've had considerable focus in this hearing block on injustice in respect of land and the illegal seizure of land by the squatters, the commutation of that seizure into Crown land and Crown claims. So how is water treated alongside land, or was it even considered initially?
So, and I think we'll draw here, Katie, jump in as well if you need to. We'll draw here on the work particularly of Lana Hartwig and Sue Jackson, who've documented these waves of dispossession. But when it comes to water, you can see dispossession both as coupled to land and the land theft, but also as decoupled from land. So Aqua Nullius, and I'll acknowledge both Katie and Virginia Marshall as the people who were the early users and coiners of this term. Aqua Nullius stemmed from Terra Nullius and the belief that land belonged to no one and therefore that water belonged to no one, and that it was available for the British to impose those laws. But that was compounded by the land theft and the specific ways in which land passed into private ownership. And there are multiple forms of that, both private ownership and, of course, Crown land, because water went with land. So when Aboriginal people had their land stolen in Victoria, their water went with that. In 2004, so a few years before the Echuca Declaration, all of the states and territories in Australia and the Commonwealth Government signed up to the National Water Initiative. I should pause there and acknowledge some states signed up a little later, but there was a National Water Initiative agreed to in 2004, which formally committed to decoupling land and water. This was a process that had been underway for some time and was now formalised as government policy. So that constituted really the second round of dispossession, because you can see the relationship between the growth in formal recognition of traditional owner land rights and then this move to decouple land and water. They occurred at about the same time, and it meant that as land rights were returned, water didn't necessarily flow with them. It did in some instances, particularly in New South Wales, but not in Victoria.
So to use the old language, riparian, when you're talking about water flows, you're talking about above ground water.
So both above and below. So land ownership in Victoria included the ability to drill for groundwater and to access that, as well as to access water from creeks or rivers. Licenses have been required now for over 100 years to access water for commercial uses for irrigation purposes, both from aquifers and from surface water. But land ownership was always part of that. And you couldn't get a licence unless you had the land to use it on.
And for domestic use, if you're the owner of the land or occupier of the land, which does not recognise First Nations occupation, but if you're an occupier of land, you can take for domestic purposes.
Yes, domestic, and I should note, and stock purposes. So there has always been an element of commercial use associated with those domestic and stock requirements.
Okay, we'll come back to the legislation in a moment. Katie, can I ask you if there's anything you want to add about this notion of aqua nullius?
The only thing I would add is that it, just building on what Erin said, it's almost a double dispossession, really. The water rights going with the land when it's dispossessed the first time round. When land comes back, it comes back without the water, so it's a double dispossession.
I think just on that, the triple dispossession, which is now the case because of the water market, because the cost of water is so enormously high that it puts it out of the reach of most Aboriginal organisations.
Carmen, was there anything you wanted to add in reflection on that? The notion of aqua nullius?
Yeah, I think we may get to it later on, but certainly the water market in the southern Murray-Darling Basin is perhaps the most, if not one of the most developed and mature in the world. So I believe it's in the order of 30 billion, the value of water entitlements in the southern basin. So a huge asset, a huge asset base and a huge wealth that has been accumulated through that process that Erin and Katie have described.
Erin, can I come back to you? You are the author of a published report. I think it's published in terms of repairing our rivers. Has that now been published?
This would be the book chapter, I think. Yes.
So could you explain to us what does it mean to give water legal personhood and what are the elements of that recognition?
So this is a global movement. Water has been recognised as having personhood in various ways. There are rivers and wetlands and lagoons and lakes in different parts of the world where water has received personhood or recognition as a living entity or a combination of both. So personhood is a little bit similar to a corporation. It's the idea that you have the power to hold rights and duties in law. So what we understand by that is that you can go to court and sue people. You can also be sued. So there are now rivers like the Wanganui, for instance, that have this legal personhood that enables them to do that. There are other rivers like the Birrarung, which are recognised as living entities, but not legal persons. And so in the case of the Birrarung, that means that the settler law recognises something which Wurundjeri people have known for millennia, that the river is a living being, but it doesn't confer that living being with any specific settler legal rights. So the Birrarung does not have the right to sue people under its current legislation. It's not a corporate entity. It doesn't have legal personhood, but it is alive. And in doing so, that presents a very profound challenge to the Water Act and its construction of water as a resource.
Thanks. We might just take the declaration down for a moment. The Birrarung is otherwise known as the Yarra River that flows through upper regions of Melbourne through the metropolitan and down into the bay. And it's a river that many Melbournians are very familiar with. So what does it mean that it has been recognised in a limited way as having legal personhood but not any particular rights? What does that mean in practice?
So, I guess in practice, it means it's almost more of a symbolic recognition than a significant legal change in that respect. It would not be possible for people to rely on the Birrarung legislation in order to sue the river, for instance. There's no legal entity there for them to sue. But, and this goes back to my previous comment, in acknowledging that the river is alive, and it's the river and its lands are alive. Now, lands has a very specific definition under the Act. It refers to specific gazetted lands. But in doing so, it's starting to recognise the river more holistically. It's seeing the river in situ, it's seeing the river as connected to its lands and dependent on that relationship. Annie Margaret Gardner, who was a member of the Birrarung Council, reminded us that the river needs its lands, and this is what that legislation starts to lay out. So it doesn't immediately create new rights and powers for the river, but it does say the mode of caring for, of knowing this river must change because it is now alive. And what that does is draw all of the various government agencies, the local governments, the water authorities, Parks Victoria, everyone who's got responsibilities under this legislation for the river. It draws them into a different relationship with this river in which the river is alive and they can start to think about a relationship of reciprocity and obligation rather than one of exploitation and domination.
So you're referring to the Yarra River Protection Wilpjin-Barung-Murrin Act.
Yes.
A Victorian statute. What's the significance of the protections under that Act if there's a development proposal that impacts on the river and riverlands? Can somebody nominate as the Lorax to speak for the river, or do we not have that sort of protection in place?
So, and this is, I will acknowledge, I'm a member of the Birrarung Council, so I'm not going to speak to, I guess, the actions of the council, but we have been appointed as the voice of the Birrarung. So in certain circumstances, we are able to speak for the river and ensure that the river's voice is heard. And there are a number of legislative provisions within that piece of legislation that enable us to do that, one of which requires us to advocate for the interests of the river. There will always be complexity about that because it is contingent on resourcing. We are a very small organisation.
So we see other models for the legal recognition, for example, Whanganui River, Aotearoa, New Zealand, the Ganges, and another river in India, where these protections are extended beyond the current Victorian protections for the Yarra Birrung. What's the next step in terms of Victorian protections? We'll come back to reforms towards the end, but I just want to capture this while we're on this topic now. And perhaps if you're on the council, you may not be able to speak about this, but others may want to jump in as well.
I think, the next step, the major flaw that I see, and I say this as a researcher, in the Birrung legislation is that, there's probably many flaws, but the one that I see particularly is the lack of connection into the Water Act. So if we were to see a next step for this piece of legislation or the next reform for it, we need to bridge that gap. At the moment, the Birrung Council is not responsible for any of the water that flows in the river. The Victorian Environmental Water Holder continues to hold the water on behalf of the environment of the river. The Victorian Environmental Water Holder is not a responsible public entity under the Birrung legislation. So the Birrung Council has no ability to work with that entity or to hold that entity to account. And they don't have to consider the Yarra River Protection Principles or the fact that the Birrung is a living entity. I'm not for a moment suggesting that they don't do those things, but they certainly don't have to. This is a problem which is a global problem. There is only one river anywhere in the world that has been recognised with any form of legal rights that also has those rights to water and flow attached with that, and that's a river in Ecuador. Every single other river and lake that has received this kind of recognition does not have any water rights, and that's including the Birrung in the sense that those rights are held by a completely separate organisation. So I would see bridging that gap as crucial.
Am I right that in Ecuador there's constitutional protections of the environment?
Yes, the Ecuadorian case emerged from the constitutional recognition that all nature has rights. And so this particular river, it was a constitutional court's interpretation of those rights to say they therefore must have minimum flows in the river.
And confirmed by the Inter-American Court.
Yes.
So others on the panel are reflecting on that discussion around legal personhood and whether this is a useful mechanism to protect waterways and the environment of the waterways, or whether it's another colonial construct. Is there a value here in pursuing this sort of recognition?
I think just reflecting on some of my time with Wurundjeri Corporation during the development of the Act and then seeing the Birrung Council sort of hit its stride, another gap for the corporation was it's a limited amount of land, as Erin was talking about. So there was definitely an understanding that would have been preferable had it not been restricted to just gazetted land, so it should have been expanded. I think, it's really the first case in the state where you've got traditional owners who've got a legislated seat having a say with other stakeholders, where a sense of traditional owners are there as rights holders amongst those stakeholders. So that's been constructive. I would also say it depends on governance, really. Wurundjeri was able to negotiate membership appointed from its own ranks and not from being ministerially appointed. So Wurundjeri Corporation has complete autonomy over who it puts forward, and the minister signs off on that. And the other thing, sorry, it's a bit Birrung story at the minute. Another thing that was quite helpful was that the corporation had words with the then planning minister to ensure that the Birrung Council sat separately from the Water Corporation, from Melbourne Water. Originally, it was going to be embedded within that framework, so it wouldn't have had that independent role. So I think it really depends on the governance arrangements and what individual nations and traditional owners would like for their waterways. But in my experience with both the source and Wurundjeri and also with Mildred, there is an interest in seeing living entities progress legally, yes.
Just staying on that theme that you've just raised, is there a recognition at the Commonwealth and state level, just focusing on Victoria at the moment, although of course Murray-Darling crosses 3 other states, is there a recognition of the vital contribution that First Nations peoples make to those boards and governance arrangements? Or do you have any comment about their participation?
I would say that First Nations being appointed into colonial settler constructs, and they're appointed by ministers, more or less. So we have many really talented people in those spaces that are building careers, which is, great contribution towards, influencing decision making and what have you. That hasn't necessarily resulted in, it has not resulted in increased water ownership in the state of Victoria. We have an additional board member who'll be First Nations appointed to the Murray-Darling Basin Authority Board, courtesy of the Restoring Our Rivers amendment. But again, they're appointed by a government process, not from a traditional owner or collective nation-based process. So First Peoples' methodologies for electing their leaders into positions are not necessarily upheld in that space. And the Birrarung Council is pretty much the only thing I can think of that captures that.
Are there qualification requirements to be appointed to these boards in terms of cultural authority or hydrology, aquaculture, engineering, any of the environmental, ecological qualifications?
With the appointment for the Murray-Darling Basin Authority, it's for someone who is a First Nations person from the basin who has good knowledge of Indigenous issues.
Mm-hmm.
So that is an example of where that's a requirement. There are other boards that don't require any particular Indigenous knowledge or skills around the CALP Act, I believe.
Yep. To clarify that, sorry.
I was just going to say, currently in the CALP Act and the Water Act, there's no requirement for an Indigenous knowledge to be one of the bases for appointment.
Yeah. So I was just going to ask, is that a criteria that only applies to the Indigenous appointment, or is that a requirement for all appointees to those boards?
Certainly for the MDBA board, I think it's one of the desirable or one of the required skill sets.
Mm-hmm.
I guess that is the basis on which they would appoint what has been one but soon to be 2 First Nations board members to the Murray-Darling Basin Authority.
Okay.
That was all I was going to say. There's no specific requirement in the Victorian legislation.
Okay.
Just be mindful when we're referring to acronyms and stuff. A lot of people are tuning in and listening to this particular topic.
Yes,
I think there was a word swoosh before. So just clarifying when you're talking about CALP Act and stuff, a lot of mob don't know.
Catchment and Land Protection Act.
Thank you. So coming back to the concept of sovereignty over waterways, rivers and river catchments, and subsoil or groundwater, can I invite each of you to reflect on this notion that sovereignty was not ceded, and the 3-stage disposition, assuming we've only got 3, but at least the 3-stage disposition that's been remarked upon by Erin. What does it mean to today's position and your negotiations with government around sovereign claims to water of First Nations peoples?
Happy to start.
Well, that's
Please, Helen, go ahead.
That's a big one. If that was recognised, we would not be in the situation that the states and the federal government are in now. It's not an historical concept. This is not something that happened 200 years ago or 100 years ago. it happens yesterday, it happens today, and it will happen into the future until we have legal instruments that are acknowledging First Peoples' first rights. And every day the water framework in the state of Victoria or in other jurisdictions does not change to acknowledge that, it is an ongoing dispossession.
And it's probably fair to say that as the water market matures, as there are new entrants into the water market and the price of water increases in Victoria, the opportunities for First Nations to realise their substantive rights to water ownership are harder, more and more difficult to attain because, as Aaron mentioned before, it is increasingly difficult to enter the water market. What that looks like now, the Victorian government has made a very clear statement that it does not support reallocation through the water market. In practice, that means purchasing water entitlements from willing sellers to recover for the environment or for First Nations ownership. So one of the only mechanisms available within the northern part of Victoria, within the Murray-Darling Basin, where water systems are fully allocated, as in all water is owned by someone. One of the only mechanisms to effect a reallocation to recognise First Nations sovereign rights is through purchasing water from willing sellers. The Victorian government has taken a very strong position against that mechanism, both in terms of recovering water for environmental purposes, but they have also specified in the Water is Life policy document that whilst they may, I think they talk about a framework for supporting that kind of reallocation, they've specifically stated in that document that there would not be a program of direct investment in water reallocation. So the historic injustice that continues to be perpetuated for us in negotiations with the government comes back to the fact that these systems are fully allocated, and the only way to effect a way to address that dispossession is through entry into the water market.
I want to ask you, following on from that, Erin and Katie, some questions around the final report, Cultural Water for Cultural Economies, and the elements that you talk about in that report, elements that point to sovereignty, what is meant by self-determination in that context, what is meant by free informed consent, those sort of issues. So are you happy to speak to that paper and the
yeah, certainly,
as you raised there around sovereignty?
So what I will say about the Cultural Water for Cultural Economies report is that this is a report which is technically authored by me and by Katie and by another researcher, Lee Godden, but this is a report that was undertaken in full partnership with Mildren and in reliance on the participation and expertise and ongoing leadership of traditional owners from 20 different traditional owner organisations. So this is not a report that we did on our own, and this is not a report that we could have done on our own. So in acknowledging that, then when we think about this question of sovereignty, what became very clear during this report, and it was also articulated in the National Cultural Flows Research Project, which was that water rights are very, very separate from water sovereignty. So water sovereignty exists at a foundational level. When we say that country has never been ceded, that's what we're talking about. There was the foundations on which the settler state has built its water laws are rotten. So when we then link it into this concept of water rights, what we're really talking about in that instance is, well, how can we start to make some change within a settler state system? So there is significant resistance from some traditional owners to the idea of receiving water rights on two grounds. One, that they don't want this to be seen as an acceptance of an illegitimate water law framework or any kind of ceding of their sovereignty. So there's that element. And then the other is that the water rights themselves are extractive in nature. So that also led to some very difficult conversations around how traditional owners can hold those water rights without becoming, in the words of Auntie Denise Lovett, black colonisers. So it's very uncomfortable.
Yeah, can you just explain that? Extractive meaning removing water from the water body.
Yeah, these rights are use rights for the water. So the Water Act sets up water as a resource to be used by human beings. It pays no attention to the inherent rights of water. It imposes some minimal limits and protections around ecosystem health, but those are very minimal and certainly haven't prevented the decline in ecosystem health that we've observed. The use rights, there are multiple different kinds, one of which is called a Section 51 licence, and that's Section 51 of the Water Act 1989. And this is often termed a take and use licence. And so that's what it is designed to enable, is for people to pump the water out of a river or an aquifer and use it on land somewhere else. So some traditional owner groups have been successful, although I will note that it has taken them an inordinate amount of time and effort in getting the state to grant them some Section 51 licences, and they have chosen to leave that water in stream for now. So it is performing a function in stream, so it's caring for country within stream, and that's very important. They are also investigating opportunities to use that water for almost any number of purposes on land, provided that they can work through that in a way that is consistent with their own laws and obligations to country. So that is underway, but fundamentally these rights are about extraction. And so that's what has been sitting uncomfortably, both with traditional owners, and I think it's been a challenge for the settler state in allocating these licences, knowing that traditional owners plan on leaving them in stream. There's some challenges around that.
So key principles you set out in that report include sovereignty, as you've described it, self-determination, that water will be held in perpetuity by each individual nation to be used for any purpose as determined by each nation, setting their own priorities, free, prior and informed consent, and partnership, so that traditional owners and First Nations are right holders and partners, not stakeholders. Yeah.
And that reflects their status as political entities. And I think this is something that I've seen shift in the Victorian context, or I should say begin to shift. But it's the reason why traditional owners are very clear they are never stakeholders, because any engagement they are undertaking with the settler state is a political engagement. They are rights holders, they are exerting and asserting their rights in that forum. So they are not merely another community group or representative organisation or minority group that government or government agencies need to take into account.
Katie, is there anything you wanted to add to that?
No, I think Erin's captured it really well.
Okay, we might pause now and go to some slides you've prepared to help those following and the commissioners understand how water is governed in this state. So I'm not sure who would like to step us through these slides, or if you'd both like to.
I think we'll take it in turns. So we might move on to the next slide. So this is an acknowledgement of country. I like to include with this acknowledgement these lines from Amberlyn Kwamulina, a Palaku woman's poem, Living on Stolen Land. And she says, "You are on Indigenous lands, swimming in Indigenous waters, looking up at Indigenous skies." One thing we hear very consistently that is reflected both in the Cultural Water for Cultural Economies report, but also in the nation statements from traditional owners in Water is Life, is that all water is Aboriginal water. So we'll go to the next slide. This is a statement that we've been talking about a lot today, which is aqua nullius, and this idea that it is an erroneous assumption that water belonged to no one when the British invaded, and that this enabled the British to then assert their own authority over the governance of water. This is a false assumption. We know this from the Mabo case. We know this as well because Aboriginal people have never ceded sovereignty, and the idea of aqua nullius was founded in that belief that their sovereignty did not exist. I'll speak to section 7, I think, a bit later. Do you want to move on to the next slide, or do you want me to cover it now?
Up to you.
What I will say before we move on then is just that this is obviously a historic decision and historic assumption by the British, but you can see it given force and effect in contemporary water law today in section 7, part 1 of the Victorian Water Act 1989. And so that part of the Act, let me just...
We can bring that up on the screen if that...
You can bring that up on the screen, that would be lovely. Yeah, so section 7, part 1 says the Crown has the right to the use, flow and control of all water in a waterway and all groundwater. And that's the contemporary expression of aqua nullius. It is not mere history, it is the very foundation on which the settler state legal system is built today.
And subsection 2 says the right of the Crown to the use, flow and control of all water is not diminished by various things, including rights conferred to other people. Right, so that's section 7. We can take that down again. Thank you. Back to the slides.
I think if we move to the next slide, that would be great.
Okay, I think this is me. Turning now to the United Nations Declaration on the Rights of Indigenous People and references to water, there are essentially only 2 direct references to water, and you find those in Articles 25 and 32. And Article 25 is basically about maintaining relationships and upholding responsibilities to country, including water, for future generations. And Article 32 is about, that brings in the concept of free, prior and informed consent for Indigenous peoples before approving projects affecting their lands, territories and other resources. And then it's actually subsection 2, which specifically refers to mineral, water or other resources. And I think what this makes clear is that water is in fact, even in UNDRIP, is being seen as a resource, which is as a very Western Eurocentric view of water. And I think that's been evident from what's been said already today. Australia does support UNDRIP, gave its support in April 2009, I believe, but it is very much lacking in implementation, certainly in our domestic law.
Just so that those following who don't understand international law and its application in domestic context, does that mean it is not given the force of law in Australia?
That's right, yes. That's. I was going to say certainly Victorian water law or Victoria should be looking towards UNDRIP as a base minimum for how it should recognise traditional owner rights in legislation. Certainly doesn't at the moment.
Is it the view of the panellists that UNDRIP, in respect of water at least, should be implemented in domestic law?
Absolutely.
And we note that recent amendments to the Commonwealth Water Act require the Commonwealth to consider the United Nations Declaration on the Rights of Indigenous People in the upcoming review of the Commonwealth Water Act in 2027.
Yep, it's a really important foundation. And the fact that it's been in international law since 2007 and we still haven't found ways to translate that into effect in Australia is appalling.
Just as a matter of curiosity, is UNDRIP or other international human rights instruments said to be the foundation for Commonwealth jurisdiction?
Can't speak to that one.
Right, that's just a...
There's been a recent inquiry into the implementation of UNDRIP in the Commonwealth Parliament, and I believe there's been some really valuable findings from that inquiry that go to that matter and as to whether the Commonwealth has authority to implement aspects of the declaration.
Next slide.
So just to give a very brief overview of the law in Victoria, obviously we've got these are the two main acts, the Water Act of 1989 and the Catchment and Land Protection Act, which you heard referred to before as the CALP Act. So there's I should start out by saying that prior to 2010, there was absolutely nothing in the Water Act or Catchment and Land Protection Act about traditional owner water rights. Then in 2010, the Victorian government enacted the Traditional Owner Settlement Act, and by virtue of that act, we ended up with Section 8A in the Water Act. And under that section, traditional owner groups with an agreement made under the Traditional Owner Settlement Act, they can access and use water for personal, domestic and non-commercial communal needs from water sources to which there is public access in the area of their Settlement Act agreement. And in fact, those Section 8A rights, they're very similar to the rights that traditional owners would have anyway under Section 8 as members of the public, which are, as has been referred to earlier, domestic and stock purposes.
So, yeah, sorry, Commissioner.
So what's the benefit then?
Very little, I would suggest.
Yeah.
The lack of benefit can be observed by the fact that none of the traditional owners who have those legal rights are using them.
Thanks.
So not only are those traditional owners who have those rights not using them, but those who do not have the benefit of that recognition and registration have no avenue under the Water Act.
Limited to those with a Traditional Owner Settlement Act agreement. Yeah.
So just coming back to Section 8 that refers to the rights of domestic use by reason of occupation, that is taken, as I understand it in practice, not to include First Nations peoples.
Unless they have those rights that are recognised by but under the Traditional Owner Settlement Act, yeah.
Thank you. So we're up to the next slide.
Well, I was going to say there's a few more aspects of it. There have been further amendments. That was the 2010 amendment, which introduced the very first expression of traditional owner rights to water. There were some amendments made in 2019, and the sorts of categories they fall into are up there on that slide for you. But there are four main ones. There's a recognition of cultural values and uses of waterways. You find that in the purposes section. There's representation on various consultative committees. They are, appointed by the minister. They're ad hoc committees for specific purposes. For instance, to establish sustainable water strategies. But for example, the sustainable water strategies, they're done every 10 years. So there's quite a limited role there. Has to be a minimum of one person on those consultative committees. It also brought in notification of specified Aboriginal parties, and specified Aboriginal parties are either native title holders, traditional owner governance entities, which is under the a group with a Traditional Owner Settlement Act agreement, or it's a group which has been recognised under the Aboriginal Heritage Act as a representative Aboriginal party. So basically what that means is it's limited to only those traditional owner groups who have had formal legal recognition. And of course, there are a number of traditional owner groups around Victoria that don't yet have that recognition. So that's another limiting factor there. The other one I just wanted to mention briefly is this last point, is that we've got this idea of consideration of opportunities to provide for Aboriginal cultural values and uses of waterways. That is something that applies to the Victorian Environmental Water Holder, water corporations and sustainable water strategies. But if you unpack that, it's actually very aspirational, that phrase. It just says consider opportunities to provide for. It doesn't require that Aboriginal cultural values and uses be provided for, merely that consideration be given to opportunities. So
but they can't be held to that consideration, can anybody? It's a consideration, right?
it's a consideration.
It's very easy to meet that standard, I guess, is the challenge. So if you tried to challenge a decision maker in those circumstances, then all they would need to say is, well, yes, we did in fact consider it and we decided not to.
Yeah, right. Okay.
And what does it mean in practical terms, in terms of the water entitlements held by First Nations people in Victoria?
I would suggest not very much at all.
We come to some figures in a couple of slides on, so can we turn to the next slide?
Okay, so dealing now with the Native Title Act and Traditional Owner Settlement Act, very limited water rights under both. In terms of management rights under the Native Title Act, the main section is Section 24HA, and this provides only for notification and an opportunity to comment on activities that might impact on a group's native title rights and interests. The important thing to note there is that even if that is not complied with, even if those notifications are not complied with, that still will not affect the validity of the Act. In terms of take and use rights, this depends on each individual determination. And in Victoria, they're basically limited to personal, domestic and non-commercial communal needs. We also have the Traditional Owner Settlement Act, and in the Traditional Owner Settlement Act, it's very clear that water is treated as a resource. And it requires a natural resource agreement, which is ancillary to an overarching recognition and settlement agreement. And under a natural resource agreement, water can only be used for traditional purposes, which in summary is defined as being for personal, domestic and non-commercial communal needs. So quite limited. There were some amendments made to the Traditional Owner Settlement Act in 2013 to allow for commercial use of certain resources. They were things like flora and fauna produce, forest produce, but water was specifically not included in that amendment.
Sorry, can I ask what it means by traditional purposes?
Essentially, that is, the definition is in what I think I mentioned before, non-commercial communal, personal, domestic and non-commercial communal needs.
In a colonial context.
Yep.
Oh, okay.
Traditional in a colonial context.
Yeah, yeah.
I think that, what you mean?
Yeah, I wasn't sure. Yeah, thanks.
It sometimes refers to customary activities, conducting ceremony and things like that, but absolutely.
How often would that happen?
Yeah, so it's very limited to a kind of colonial construct of what the state thought, First Nations would want to, or be able to use water for, I suppose.
They're also not rights that you can prevent other people from usurping. So, for instance, if you have a Section 51 licence right, then the state will take that into account when allocating anybody else's water rights. And so your water right becomes, in as much as there will be flow in the river, it is a defensible right. Whereas a Section 8A right under under the Water Act, based on a Traditional Owner Settlement Act agreement, is not defensible. So if there's no water in the system, then there's no water for traditional owners' uses of any kind. And they've got no ability to challenge the way that the state has allocated that water to other users purely because there's not enough left over for them.
I'm not seeing or hearing anything in the Act at all about any recognition of self-determination. So there's recognition, the word, or consider values, but nothing about self-determination, inherent rights, or anything like that.
No.
Just to answer your question, Commissioner Hunter, traditional purposes is defined in the Act, the TOS Act, Section 79, in relation to a traditional owner group, which is also defined, means the purposes of providing for any personal or domestic needs of the members of the traditional owner group or any non-commercial communal needs with the members of the traditional owner group.
I might just touch very briefly on the fact that there was a first principles review of the Traditional Owner Settlement Act, and I think the report came out in the end of 2021 or maybe early 2022. I couldn't quite work that out, which was looking into how to improve the Traditional Owner Settlement Act. It did acknowledge that the Traditional Owner Settlement Act is not sufficient in terms of water rights, but the review also acknowledged that the review didn't actually consider water rights in any detail. So there was a recommendation to have that looked at in further detail down the track, so to speak.
Is that something that, to your awareness, is happening or has support generally for that specific review?
Probably the Traditional Owner Corporation's a better place to answer that question, I would say, because the First Principle Review Committee was comprised Traditional Owner Corporations and their staff, and that's the Act which applies to them. So,
but in terms of government willingness or an indication that they'll support a review, or
I would say that given there's been limited progress on it to date, that it's not getting a lot of traction, but you'd need to test that with the talks.
Sorry, you also mentioned that in 2013 water was not listed. Do you know the reasons why water was not listed? Was it not thought of, or?
I don't really know, but I can assume that it would have been raised, and for that, and not included because there were other things that weren't included as well. It was a limited number of commercial rights. I think it was maybe a slowly. Let's start with these ones.
We might ask the state about that. All right, the next slide.
Okay, so this is back to me. This slide really speaks to the ongoing impacts of this exclusion. So across the Murray-Darling Basin, Aboriginal organisations own less than 0.2% of all water rights on issue. In the state of Victoria, as at September 2022, 0.18% of water rights on issue were held by traditional owner organisations. So the impacts of Aqua Nullius are continuing today. I think it was in 2022, a report by the consulting group AETHA found that the water entitlements on issue in the Murray-Darling Basin were worth $35 billion. And that's just the water. That's not the concomitant use of the water to support irrigation development or any other economic uses. So the multiple waves of dispossession, the ongoing dispossession, the ongoing exclusion of Aboriginal people and their interests from water has resulted in significant economic loss. I think it would be very valuable for the state to actually document that loss and what that means. So that's what this slide is really pointing to, is to say this is not a historical artefact, this is an ongoing problem. We'll move to the next slide, please. This diagram comes from the National Cultural Flows Research Program. This was a way of outlining pathways to address Aqua Nullius. And you can see in here the three pathways that are picked up in the Cultural Water for Cultural Economies report and to a certain extent within Water is Life, the government policy document in response. At the beginning, or at the sort of the central point there, is the idea of water rights. As I mentioned before, water rights exist within the settler state system. So they are settler state constructs. They can be transferred to traditional owners, and several traditional owner groups have certainly done so. And this is an opportunity to to gain power, to gain the opportunities to use water for cultural purposes in whatever way they see fit. But it is still very much within the settler state system. It is also, as a result, one of the easiest options for the settler state. It's entirely within their capabilities right now to find and to support and to fund the water rights returns to traditional owners. The second circle there is about influence in water landscapes. And so this is a recognition that it's about the authority to make decisions about how water is used and how waterscapes are known and cared for more broadly. And so again, this is about saying traditional owners need to be able to exercise their authority within that space. This presents more of a challenge in some ways to the settler state because this is about power sharing. At the third circle is the idea of transforming foundations, and this is where treaty comes into the equation, because we're talking about the kind of significant changes to the very foundations of the relationship between the settler state and Indigenous peoples when it comes to water. So there's many elements that can still sit within there. It doesn't necessarily have to be solely treaty. There are other forms of agreement making, but it is saying it can't be constrained by the settler state system in that way. A couple of things about this diagram. All three of these can be pursued at the same time. So you can return water to traditional owners whilst negotiating a treaty that might actually foundationally reassess Aqua Nullius, for instance. You can return water rights whilst also appointing traditional owners to boards of water authorities or other mechanisms that enable them to exert authority in the way that waterscapes are managed. So all of these things can happen at the same time. It certainly doesn't have to be sequential. And individual traditional owner groups may also choose to participate in one or more of those circles. For some, they are only interested in transforming the foundations and nothing else has meaning until they've had that conversation. Others, as I've said, are actively pursuing water rights. If we move to the next slide.
I just ask you before you move on, in the transformation circle, what's recorded there is a series of processes, and of course Yoorrook is part of the potential transformation.
Yes.
But if you were to provide us with a series of actual transformative actions, what would they be?
So I think, yeah.
I mean, it's one thing to say, let's sit down and talk, but what about?
Yeah.
Where does it get to?
So, yeah, I think I'm struggling to answer that precisely because I can't speak for traditional owners. So the specific actions will need to come from nations and probably also the First Peoples Assembly. But what I think we can point to coming out of the nation statements in Water is Life very clearly that traditional owners are highlighting is foundationally an acknowledgement and addressing Aqua Nullius. So Water is Life is currently the only government document that I know of in Australia that acknowledges that Aqua Nullius is a thing. It does not address Aqua Nullius at all. And it doesn't acknowledge the problem, the major problem that it presents for the foundation of settler water law in Victoria. So it has taken the very first step. So I think the kind of transformative things that we need are actually addressing Aqua Nullius, acknowledging that it does present this foundational problem and developing strategies to address that.
What are they? We can acknowledge and we can have frameworks, but what do they say in there? Do you say that there should be, a return of water to Indigenous people?
We appreciate you're not Aboriginal, right? Yep. So I think we just got to be able to move past that.
Yeah, okay.
And just be able to talk about the things that you've engaging with mob for a very long period of time. And this is a blanket rule for the whole panel. But we're asking kind of you to be able to give your thoughts. We understand you're trying to be sensitive to our people as well. But just be transparent in your answer. Probably.
If it would help to refer to Caring for Country or Water is Life, please do so.
Yeah, no, I think specifically, and again, this is now speaking from my perspective and as a researcher, you're talking about contested sovereignties. And so this is the really hard thing. But what it comes down to is all water is Aboriginal water. And so what I'd be looking to see from the settler state is a genuine acknowledgement of that. What does that mean? How do they make peace with that idea? How do they re-embed that idea? So if we look at Section 7 of the Water Act, for instance, the Crown should not have the authority, the sole authority, when it comes to issuing water rights and making decisions over the way that water is managed because of those contested sovereignties. So addressing Aquanalius would mean, for me, one of the things it could mean is that the Crown and traditional owners might share that authority. Potentially, traditional owners might hold it solely and then work with the Crown in order to give effect to it. So there are some really foundational level reforms that you could look at. I think there are ways of progressing those reforms that don't necessarily mean an immediate upheaval of the way that water will continue to come out of taps. There will be practical processes to enable that to still happen. But this is what sovereignty never ceded means, is that all water is Aboriginal water, and the Crown certainly does not have sole authority. So that, to me, that's how you can address Aquanalius, is to tackle that provision and then the flow-on effects that it gives rise to.
Just before I invite other panellists, whether there's something they want to draw out of these documents, to let commissioners know we have substantive submissions, Caring for Country. We have a substantive document produced, Water for Life. We have cultural water for cultural economies, a number of resources available that throw up actions, whether that's around ownership, licensing, water returns, around protection of cultural and heritage sites that are near waterways. There's a vast range of things. So I'm not expecting you to be comprehensive in your answer, but if there's something you'd like to highlight, please do so.
I agree with Erin wholeheartedly. I would also say that Water is Life has some good aspirations in it, but it doesn't go to the heart of addressing that issue whatsoever. We have an action in there that was supposed to be delivered between 2022 and 2023. So even when there's a very easy win for the government, which is the 1.36 gigalitres that was committed to the north of the state, it has not been delivered. It is not in traditional owners' hands, and that work does need to be progressed.
So come and just explain that 1.6 gigalitres came from where?
So that 1.36 gigalitres was, I guess it was returned from an infrastructure and an efficiency upgrade in the north.
These were seen as savings.
Yes, savings, additional savings. I
think it's important just to give the context for this one. We were going to cover it a little bit later, but I think just to contextualise what you're talking about here, this is 1.36 gigalitres. That was 2/3 of a second round of additional savings that came from a project that was committed to in 2007 as part of the Victorian Government's next stage water plan, in which 75 gigalitres were going to be recovered for the environment, for Melbourne, and for irrigators. They were each going to get 75 gigalitres as a result of these efficiency savings. 0 was going to traditional owners. In the intervening period, the Victorian Government passed a number of policy statements which indicated that they would consider, at first instance, traditional owner interests in water that became available for allocation. In 2021, Mildred and I had to hold the government to account on that because they found the first round of additional savings was 2 gigalitres, which they gifted promptly to irrigators in full. So the 1.36 has come out of a process which first initially completely ignored the interests of First Nations, then completely ignored the government's own policy, and was only after significant action in the press, really, from Mildred and others, that the second round of savings was then found and shared in part with traditional owners.
And is it correct, Erin, that the final extra 2 gigalitres was initially, 2/3 of it was initially earmarked for the view for the Victorian Environmental Water Holder and for Melbourne retailers, but they chose to gift that?
The press release implied that they chose to gift that to traditional owners.
Could I just pursue for a minute this. I'd be interested if any on the panel are able to enlighten me about Water is Life and any, firstly, actions within the document, actions, not forming committees, not, I think they, as I remember it, they have outcomes projected for the 3 years and then 5 years. But as I read it, they're almost all, and as I say, if you've got some enlightenment, it would be great to hear. But they all speak in terms of sitting down and talking about something. There's almost, sitting down and talking about maybe Aboriginal people on more boards, but there's nothing that I could see that you could set out as a hard achievement. That's in the document itself. And the second question is, well, we're already up to the 3-year mark. What's the scorecard, man?
I guess, one positive action that I'm aware of that has been progressing is I believe it's under Targeted Outcome 3, localised pilot environmental watering project. So I do know that the Victorian Environmental Water Holder is working with traditional owner groups to develop guidelines and to support them to submit seasonal watering proposals.
So this is a pilot to produce guidelines.
So with the intention of allowing them to be able to submit their own watering proposals rather than having to submit them to catchment management authorities. So that is an admirable procedural improvement, but I should stress that it's within the frame of, it's within the frame of process. It doesn't provide any substantive water right or water ownership to those nations. It just allows them to have more self-determination in that process of identifying where environmental water, which is still held by the state, should be used. But that is one that I'm aware of. Others probably have,
Yeah, but I wonder if that, Tony, then comes with resources for First Peoples to be able to do that work, right?
Yeah.
Does it?
I believe there is some, yes.
I am going to jump back to...
My follow-up question is, this is a pilot to produce guidelines to enable Indigenous people to do something. My question is, aren't they able to do it now? Don't they have the expertise without doing a pilot to produce guidelines? And if that's so, it gives me a very distinct feeling that this is, bureaucracy added to bureaucracy in order to, well, I don't know if it has the intention of delaying, but it certainly has the effect of delaying what would seem to be quite a simple operation. Am I missing something? Because I don't want to put my foot in it without knowing that actually there is a proper basis for suggesting that this is sort of over-elaborate bureaucratizing.
I guess just to add to that point, my understanding is that to get to the point where the state would accept that traditional owners would be able to make their own seasonal watering proposals, that in itself was quite a bureaucratic wrangle. So there is the mechanism previously was that all seasonal watering proposals would be prepared by catchment management authorities to be submitted to the Victorian Environmental Water Holder. And there was I think a degree of reluctance initially in allowing that process to be opened up or considered. Certainly in some cases there would be traditional owner groups that have the capability to do that now. Others may need further support and assistance to do that.
And I think a lot of the new guidelines and the pilot program is actually largely for the benefit of the government agencies because they didn't know how to do this. So traditional owners are saying, we're ready, we've got a proposal. Not all traditional owners, obviously some groups are more ready than others. But this was government trying to figure out how it can do that work. It is a bureaucratic process.
I think there was a question put forward before from Commissioner North about the transform foundations. So I just wanted to give everyone an opportunity to go back to that because we lightly touched on it around, water sovereignty. Is there any other thoughts and suggestions that you have been thinking about? Again, full authority to kind of, speak, so to speak.
Well, water entitlements straight away. That's going to help. If you have an entitlement, you're at the table.
And the current situation with water entitlements is
0.07
0.18.
in the state
and
of
are they
Victoria.
on the table at the moment?
Water for Life, and this, we're speaking with a particular focus around our membership, which is in the Murray-Darling Basin, where water systems are fully allocated. Water is Life's agrees to develop a framework to support traditional owners entering the water market when no alternative pathways to water for economic development are available, or for water that they can use for their self-determined purposes. But the Victorian government is not proposing to establish a direct water entitlement purchase program. So there are very specific barriers to addressing that.
Can I just pause for a moment to note the time? We have gone a little over time and we're on a very interesting topic, but the time is 4:26. So would you like to continue with this topic subject to the panel having it been convenience to them to continue?
It's good.
Happy to stay. I'm seeing some nods. Yep, thank you. So yes, you were talking about priority actions that take it beyond a plan to develop a strategy.
Yeah, and I think to answer the Commissioner's question, we deal largely in pragmatic outcomes. I think this model has been incredibly useful for us to be able to advocate for the kind of broad change that's needed. But in reality, a lot of our advocacy is focused around immediate opportunities and addressing immediate gaps that we can see. A recent example is the Restoring Our Rivers Bill in the Commonwealth Parliament. So I think all the things that Erin mentioned before around addressing that fundamental basis of water legislation, we would love to be able to work more on that, but we're often putting out spot fires in sort of pragmatic sense in trying to advance First Nations opportunities to, get hold of water entitlements, for example, or have greater procedural rights in making decisions about how water is used.
To be fair, there's just no program of reform currently in Victoria around water. Like we have a policy piece, but not a strategy. We've got the north and the south. The north of the state is not going to be able to achieve water justice without significant financial investment. So that has to be on the table.
Should the government commence acquisition of water rights and entitlements immediately on behalf of First Nations peoples?
Well, I think it's overdue.
The option there also is to fund First Nations directly to do that.
So that they become the purchaser.
Yes. And there would be, there are a number of different ways that could happen. But I guess the Victorian government has known since March 2021, when the Cultural Water for Cultural Economies report came out, that there are no clear pathways for substantive restoration of surface water access rights to traditional owners and First Nations in Northern Victoria unless they go to the market.
And I think I saw somewhere in the material the current guaranteed water or high value water is currently $4,500 per megalitre. Is that about right?
I would expect it to be much more than that. High reliability water in the southern Murray-Darling Basin tends to go between $5,000 to $6,000 per megalitre in a permanent entitlement.
I also remember reading, and I can't pinpoint it immediately, but that there was a fund, a Commonwealth fund available which hasn't been used. What's the story about that?
That's a tortured story that Will has good context for.
Yeah, so there is now $100 million which the Commonwealth Government has allocated for purchasing of water entitlements for First Nations in the Murray-Darling Basin. So that's for the whole basin, so northern, so right up to southern Queensland. That was committed in 2018. There have been various machinations and sort of toing and froing around that. It is at a point where it is certainly moving forward now. There are still questions about how it's going to be delivered and to what extent First Nations have ultimate sort of control of that process, but it's certainly moving forward more rapidly now.
Out of that 40 million, how much hit the ground?
None of it has been spent yet. So it was initially
40 million initially in 2018.
now up to
Now it's 100 mil, but the initial 40 mil, none of it hit the ground.
Yes, zero. And we actually were able to have some work done to calculate the lost value or the foregone value of that funding, the 40 million component. It was committed in 2018. I don't have the figures in front of me now, but it was about 50% of the value of that funding was lost in the intervening period just because of the increase in water entitlements.
Yep. So today, 40 million would buy 2/3 of the water that it would have bought in 2018.
So why didn't it move? I mean, we're now 6 years later.
Frankly, I think it was an ideological unwillingness to support the actual outcome of the policy.
So just on that, you wrote a letter, well, Mildred wrote a letter on the 26th of April 2021 to the State Minister, the Acting Minister Richard Wynne, about that 40 million and the commitment made by Federal Water Minister then David Littleproud, committing the $40 million to support the acquisition of water for cultural and economic purposes. And recently, at the time of writing the letter, you say you were alarmed to hear in a recent Senate estimates hearing an associated commentary then Federal Water Minister Keith Pitt was contemplating redirecting the funds.
That's correct.
Yep. And in that letter, you demanded certain things around that 40 million, including a commitment it not be repurposed.
Keith Pitt is also on record speaking against Minister Plibersek's decision to accelerate the expenditure of that money after the Labor government came in.
That's correct, yes. So the previous Commonwealth Water Minister referred to that $40 million commitment as a wealth transfer from farmers to First Nations. So under the previous minister's leadership and other ministers that preceded him, that program did not advance at all. And we actually, that correspondence was related to, we were seeking support from the Basin State ministers and the Basin State premiers, including the then Victorian Premier, to guarantee through the Basin Ministerial Council that funding would not be lost. Thankfully, it wasn't lost.
Is the 100 million that you were speaking about $100 million per year provided by the Future Drought Fund, or that's different money?
No, it's a one-off $100 million for purchase of entitlements.
And is there an allocation under the Commonwealth Future Drought Fund?
Not for purchasing water entitlements.
Of the 100 million, what would Victoria be expecting?
That sort of comes down to the governance, the water entitlement purchase and the governance arrangements, which are still currently being developed. There were some scenarios that were developed to support First Nations make a decision about what sort of package of entitlements to acquire. Some would be in Victoria. How they would be held is still being considered, and they may be held in some. The Commonwealth Department has recently called for applications to an interim governance model for that to manage the entitlements acquired through that fund. So there would be an interim governance model made up of two First Nations directors and an advisory committee. They would, in the interim, manage the water entitlements, or they would initially do the purchase and then manage it. And the intention then is it would cede to a self-determined model once that self-determined model has been determined.
What I'm interested in is the present figure is 0.1% that Victorian EOs have access to. Would an entitlement, would a proportion of this, whatever it is, and that's a bit of a problem to work out, be a significant increase?
I would say no.
I would not think it would be a significant increase.
Not in percentage terms. It would be possible to double the total amount of water owned by traditional owners.
I see.
But it would still be a very tiny amount of water.
The proportionate increase would be 100%.
Yeah. And so this is
less than 1%.
It would, I would still be, so it's 0.18 right now. Yeah. So you could double it and get to 0.36, and you're still less than 0.5%.
Sure. But At least imagine the annual report, we double the water intake.
So this is also a question which is playing out in terms of setting a water target for the Closing the Gap policy space, because how do you set a target when the increases that you need are so substantial? So yeah, it's a live conversation.
Just can we turn to your last slide in this bundle and the roadmap to water for economic development slide?
So this slide...
Sorry, not this one. Oh, sorry. I was going to jump to the one after this.
Well, I think it's actually worth spending a little bit of time with this one because this goes to your question earlier about the difference between cultural water and some of the other ways. So this is a diagram that was created by Melissa Kennedy. She's a tatty woman. She was, along with me, she was part of a majority traditional owner writing team on secondment into government to help them produce Water is Life. This diagram was a way of conveying to non-Indigenous people what cultural water and cultural flows actually represented. So there was an assumption by many people that cultural flows were the same as environmental flows and that they certainly didn't represent things over which traditional owners had significant control. And so what this diagram says is actually a cultural water paradigm is a holistic way of knowing and understanding and caring for water. And it brings in sovereignty and self-determination, connection to place, responsibilities to country, emotional and spiritual well-being, cultural experiences, and it then intersects with healthy country, healthy people, and cultural economies. And so this was a really powerful way of conveying to non-Indigenous people that there are elements of cultural water that overlap or intersect with environmental water. It's not the same because environmental water is informed by settler state science and settler state authority for caring for water. But healthy country is part of it. Healthy people intersects with the settler state understanding that water is provided to households. Cultural economies reflect the fact that water was always used to support thriving, prosperous communities. It's just not the capitalist extractive model of economies that we see playing out in the settler state today. So this cultural water paradigm was a way of communicating the ideas that are in the Echuca Declaration.
So just to close this off, in your slide session, in your submissions, you have set out a roadmap to water for economic development and offer various pathways, suggestions for Northern and Southern Victoria, including a summary at the end of various targeted outcomes and action required. So can I invite you to offer some closing remarks around what is most important, given the questions of the commissioners around what's next? What is most important and what is foundational or essential to that step? Because obviously if we tweak some legislation, that might give you something minor in the meanwhile, but essentially, if you're looking for holistic reform, what's needed?
So I will say the rest of these slides are a descriptive set of slides to lay out the frameworks that are in place in Victoria at the moment. So they're not necessarily our recommendations. In terms of the big ideas, I think we've talked about one, which is addressing aqua nullius, and Section 7 in the Water Act is the key expression of that. During the Water is Life process, traditional owners advised the state government that they needed to see evidence that the settler state water framework is moving closer to traditional owner ways of knowing and caring for water. And so one of the big ticket items, I think, then on that is settler state legislation that enables traditional owners to have their living entities formally recognised within settler state law and have that legislation connect into the Water Act. So this is targeted outcome number one in Water is Life, is the development of this new legislation. We haven't seen anything yet on that, although I understand that there are some traditional owner groups who have been receiving briefings, and that's excellent, but it's also 18 months on. This was a well-progressed idea 18 months ago, and so it would be really useful to start seeing that out there. The other thing that is crucial, I think, is around water returns. And so we've talked about Northern Victoria and the need to fund water acquisition, but Targeted Outcome 7 says that the government is going to act quickly on existing opportunities. And yes, I know the Commissioner's laughter in the corner. I will just very briefly articulate what is in our submission here, which documents 4 water licences, each of which took over 12 months of sustained advocacy and leadership from each traditional owner group in order to get that licence returned. This is unallocated water. It is water that nobody is currently using in the settler state parlance. It is water that will remain in stream. It is literally the easiest water to return to traditional owners. In every instance, it took over 12 months. And I'm not talking 12 months of just waiting for processes to happen. I'm talking regular meetings, frequently monthly meetings between senior traditional owner organisation staff and senior staff inside the state government or inside the Water Authority. So this is not the usual process that a farmer would need to go to in order to get a water licence like this allocated. It's baffling to me. And so the first one was finally handed back in March 2021 to Gunai Kurnai. Again, this was a 2-year process. Having done one, we anticipated that the settler state process might speed up a little. The next one was September 2022. This was a 2.5 gigalitre water licence to Gunditj Meering Traditional Owner Aboriginal Corporation, again, which took well over 12 months. This process was initiated by Gunditj Meering at a workshop as part of the Cultural Water for Cultural Economies project in February 2020. So that was a very, very long time between that. In October 23, Gunai Kurnai again received additional licences, but they took again over 12 months and 12 months of consistent advocacy. Wurundjeri Woiwurrung have been waiting for the return of a water licence that has been held by the state government. So they have held it and they've committed to returning it since 2020.
Can I ask you, those 4, if you add them all up, what proportion of the 0.18% do they account for, do you know? I mean, again, a large amount or a minuscule amount. I just want to get some idea of the proportion.
So they are, I think, so the 0.18% does not include the Gunditj Meering or the 2-second Gunai Kurnai. So it would go up a little bit. It might be up to 0.2% perhaps, but
minor.
Very minor.
The other question is, you said that this is unallocated water, therefore there's really no impediment to handing it over. But is that observation going to be correct always? So that, I mean, is this a particularly good year where the water is available, but what about next year or the one after where
it's not,
these are permanent entitlements, aren't they?
They're water licenses, so they're actually only issued for, I think it's 15 years, although that varies slightly from jurisdiction to jurisdiction. So the 15-year licenses, there is an assumption that they will be rolled over each time. So at the end of your 15 years, it's not a free-for-all. The Water Authority tends to just reallocate those. Because they're permanent, the water availability each year within your licence will change. So you've basically got the right to extract water from a stream. If the stream drops below a certain level, they will put licence holders on restriction and prevent them from accessing it. But the unallocated water, they have already determined what the sustainable diversion limit is for these streams and aquifers, and this water sits within that. So they know that it's sustainable to allocate this water.
For at least 15 years.
For at least 15 years, yes. And there may, climate change may impose the need to reduce water licences in time. That is something that should affect all water licence holders. I have been told in an informal way that one of the barriers to allocating water to traditional owners in this way was because people could see climate change coming and they wanted to reserve that water to maintain existing reliability of supply. That, as far as I know, has not been any kind of formal impediment, but that is clearly in the minds of some people in those roles.
And there's an opportunity, what you're saying there, for TOs to be involved in the underutilised. Is that what you're saying?
So there's two opportunities here. One is unallocated, which is primarily in southern Victoria. This is water that nobody formally owns. There is the underutilised water, which is a different bucket of water entirely. And by that, we're meaning the 75 gigalitres that came out of those water savings that we were talking about before, and that is formally owned by the Melbourne water utilities. So it's owned by Greater Western and Southeast Water and Yarra Valley Water. They each have 25 gigalitres. There are rules in place that prevent them from accessing and using that water for the purpose for which it was intended, which was as a drought response measure for Melbourne. It cannot flow down the north-south pipe to Melbourne's supplies, except under very extreme circumstances, which would require, and this is me paraphrasing, so it would be worth going and getting this material specifically, but it would require Melbourne to be in the most severe drought it has yet been in, and Northern Victoria to not be in any drought at all, for any of that water to flow under the existing rules. So those water authorities at the moment, the only thing they can do, they had to spend a lot of money to help pay for the recovery of this water. They are recouping that cost and their ongoing fees and charges of holding that water by selling their allocation on the market each year. So each year they'll get a certain percentage of their 25 gigalitres and they then sell that to irrigators. So we consider that to be underutilised water because not only were traditional owners excluded from that process in the beginning back in 2007, but this water is not performing the function for which all Victorians, including all Melbourne people, have paid in various ways. So it's not performing that function. It's therefore open to the government in consultation with those water authorities to think about, is there another use? But 75 gigalitres in Northern Victoria, that would be a significant volume for Northern Victorian traditional owners.
This has been available?
How long has it been available? It started, I think they started receiving the water in 2017, I think, as a result of the savings, but it's steadily increased. And their water entitlements, I can't remember exactly when they were formalised, but yeah, they certainly have their formal entitlements now.
I was just going to point out that under the Water is Life Government Action Plan, the statement is made very clearly in terms of water returns. The Victorian Government is not proposing to establish a direct water entitlement purchase program. So they have foreclosed a water entitlement purchase program.
They have, and they have not foreclosed funding traditional owners directly, but they have certainly foreclosed anything that resembles what we're seeing on, by the Commonwealth, for instance.
Carmen, yep.
I might just add in that during the Central and Gippsland Sustainable Water Strategy, that included 16 water industry organisations, and they created a water sector statement of commitment that included Melbourne Water and its 3 sort of subgroups that it gives its water entitlements to. And some of those commitments were specific to the geographic footprint of that Gippsland strategy. However, there are other statements there that are not specific to that region. They're broader, acknowledging the legacy of past decisions, and we as the water sector members are committed to transforming current systems and building a new future based on restorative justice and traditional owners' self-determination. They specifically outline a commitment to rights. We support the rights of all Aboriginal peoples as outlined in UNDRIP. And advocacy. We will advocate in partnership with traditional owners and others to address the gap in social, economic and health inequalities experienced by many Aboriginal Victorians through returning water and decision-making to them. So this 75 gigalitres of water, which is otherwise not going to be available for any mobs in the north, is going to be really a good opportunity if this could be actioned.
Just observing the time, are there any other questions from commissioners or any other final comments that the panellists would like to make? We haven't covered aquifers, we haven't covered seawater, sea country, but you have your submissions.
I would love to briefly read from one of the submissions to the Water is Life document. We have permission from Taddy Nation to read out some short messages, I suppose, from their submission, which really, I suppose, go to some of the Commissioner's questions as well around sovereignty. So I'll just read briefly from this statement. We are Taddy Taddy. This is our country. We demand to be the water owners. We demand to be the water authority. We do not want to come under anyone else's authority. We require dedicated and long-term funding to be re-established as the water authority for our country. We require dedicated and long-term funding to re-establish cultural water economies. We require allocations of water with no fees and no charges. We require cultural flows annually. We call for the government to relinquish control. We call for the power of sovereign nations to be reinstated. We demand our stolen rights to be restored.
Yeah, thank you, Will. And for Commissioner's benefit, that's set out on page 231 of the Water is Life document.
I think the other thing worth noting, Water is Life exists. It is not a perfect document by any stretch of the imagination. The most powerful parts of it are the nation statements from traditional owners. So one of the things that the settler state has been able to say in the past is that it doesn't know what traditional owners want. They can no longer say that. When it comes to the settler state commitments, what we're lacking in that space is transparency. There is no indication, as Carmen and Will have previously commented, that this is being implemented or that it's being implemented in anything resembling a timely fashion. So there doesn't seem to be any kind of public reporting on what Water is Life implementation looks like. And so without that, how do you hold government to account? How do you measure progress? How do traditional owners continue to have good faith in the actions of government? So I think that transparency, that commitment to ongoing accountability and reporting is also a statement from government that it's taking it seriously and that it's genuinely prioritising the work, even the bare minimum that it itself has committed to.
I'm a little concerned that we haven't dealt with sea claims, sea issues, and I'm just wondering, it probably only concerns Erin and Katie. How long would you assess it would be necessary to spend on that issue if we did it on another occasion?
We are going to take the Water Minister to those things and the various research articles that are relevant on that topic, Commissioner. So
that's a different perspective, though.
I mean, if you wanted to spend time, it would be worth hearing from traditional owners that are developing sea country plans. And so that's Gunai Kurnai and Gunditj Miri. So that would certainly be worth hearing from them. Otherwise, I think it's
meant that if the two new work to address it, is that within your area of expertise?
I think we'd invite one of the other authors from the submission to join us in that.
Who would that be? Would that be
That's
Sue?
Kate Jarmer.
Okay.
Thanks for that.
No worries.
So if there are no other questions, it remains to thank the panel for their attendance and note that we didn't get to all of the matters that we wanted to raise today. Nevertheless, we have your submissions and note of your work, and to thank you for your participation and the important issues that you flagged for us today.
Thank you.
Thank you very much.
Thank you, Council, and thank you all very much, panel. Thank you.
There is one task I need to attend to, so if the panel are just happy to stay sitting while we do that, and to note that Ms. Caffarella needs to leave at any minute, so she might bolt in the middle of this. The intention is to tender some bundles of documents. Chair, there are 13 documents on a tender list produced from the first panel, and that was obviously the first week. A list of 9 documents from the Surveyor-General today and 11 documents today. I'll just check that picks up correspondence that we referred to, the Mildred correspondence, not only the letter of the 26th of April 2021, but 2 letters that are dated 2017 as well.
Entered into the record. Thank you.
And that concludes today's hearing. Thank you, Chair.
Thank you. We adjourn until tomorrow morning. Thank you.
Good work.